2023. In fact, this is reported as a 1.5% increase. On the other hand, the International Environmental Agreement Database Project records 3,749 agreements as of to date, agreements on combating climate change and conservation. Billions of carbon being released in the atmosphere yearly, while agreements are in their thousands. Where are we getting it wrong? Adjudication panel and esteemed audience, my name is Bobby Deman. My thematic paper looks on international climate agreements and negotiations, analyzing the effectiveness, outcomes, and implications to global cooperation and global climate governance. The Swahili pronounce themselves and say, Mgala muue, lakini haki yake mpe. This research paper will first acknowledge the role of these agreements in climate governance and global cooperation. One, I look at global cooperation, and the research paper posits that these agreements have undeniably played a critical role in political momentum and global cooperation. I look at the Montreal Protocol of 1987. It comes out as a first agreement to tackle ozone-depleting substances. Recently in Kigali 2016, through an amendment, it comes explicitly for hydrofluorocarbons. Such an agreement and its success cannot be ignored, and in fact, it shows that some of these agreements are driving meaningful change. In global cooperation, the research paper posits that we are moving and inspiring action through these agreements from global levels to municipal and local levels. The research paper gives an example of the Climate C40 Cities Agreement, where cities come together to combat climate change. These cities come together and they look on areas such as a circular economy. They go to transport decarbonization of waste, in fact, in the public transport, and they also look at the refitting of urban spaces to allow for green spaces. The research paper then moves that this inspiration is moving from global levels from global legislative halls to regional legislative halls. I come back home and I look at the Climate Change Act of 2016, enacted as a response to our commitment in the Paris Accord of 2015. The Climate Change Act 2016 gives Kenya a framework to promote low carbon development. We also see we are setting up a council, and it sees Kenya put its targets to 32%. Secondly, the research moves and in fact formulates a concept through these climate agreements, or rather acts, and it terms them as actionables. What do I mean? That these are concrete, enforceable provisions that require nations to move from theoretical commitments to actions. Paris 2015, in fact, epitomizes this shift through the nationally determined contributions. As a response, we see countries set up projects so that they can meet the emissions, the targets that they've placed. This research paper gives an example of Morocco, which sets up the Noor Quazarat solar project, which gives the country around 380 gigawatts of electricity. And esteemed bench, this in fact translates to a minus 280,000 tons of carbon. at least a minus to the billions of number I raised in my introduction. From Morocco, I go to Bangladesh. The CAN-CAM adaptation framework gives the methodology for implementation. As a response, we look at the agreements and the countries, and the country of Bangladesh putting a climate action strategy which acts in mitigation and adaptation. Esteemed bench, we are seeing that these agreements are moving from declarations of intent to compel action. Thirdly, I look at the aspect of climate financing. This paper says that this has played a major role in climate governance, all the way from Montreal to the Copenhagen Accord of 2009, where the Green Climate Fund is set up to finance projects all the way from the Pacific to Africa that promotes sustainable living, and a project in renewable energy. This research paper in fact discovers that climate financing is moving from a pre-adaptation stage to a post-consequential stage. In COP27, there's a setup of a fund, the Loss and Damage Fund, where the countries who are being least in emissions but are being heavily affected and getting irreversible damages, they are being compensated. This demand comes from who? The global south. Interesting people who I'll get to in a minute. Esteemed bench, the title of this research paper took the form of an equation. The equation moves to it that when you open a bracket, put agreement, add the letter Y, close that bracket, multiply it by a subscript N. Esteemed bench, I know we profess a profession that holds a different view of the discipline of mathematics. This is what I intend to say, that each agreement represents a bold step in climate action. But as years go by, the gap between actions and commitment is often widening. This means that this is a cycle that is repeating, which is denoted by the subscript N. This paper recognizes that to praise something and not critique it, it's ignoring its potential. That in fact, appreciating something is also recognizing its flaws. This paper moves on to critique these agreements. When I term that these agreements, a gap is existing, the paper formulates a concept through these agreements, or rather acts, and terms it climate activism. That these agreements are ambitious on paper, but they are promising bold climate action, but they are lacking meaningful implementation. In fact, the paper terms it well and calls it the gap between rhetoric and reality. We go to Kyoto 1997. The Kyoto Protocol comes out, set up to reduce the greenhouse emissions. In its first commitment period in 2012, we in fact realize that greenhouse emissions have significantly increased. Member parties like Japan, who their estimates are around 77 billion tons of carbon, when asked what happens to the commitment of the framework, a response is given that in the second commitment period, we pledge to meet our obligations. I take you to Rio plus 10, Rio itself, and Rio plus 20, where the world sits and formulates a document called the future we want. Today, in that future, this is in fact not what we wanted. That they put sets on goals on biodiversity and greenhouse emissions And in fact, in a post-analysis period, these goals remain largely unmet. This paper moves that this recurring pattern is showing that we are very good at negotiating and getting to the tables, but there's a challenge in moving from the agreements table to the real world impacts. Secondly, this paper recognizes that in these agreements, we have flaws in accountability and we are relying on speculative technology. Paris 2015 comes out, sets out the nationally determined contribution and tell member states, give us your targets. So member states give their targets. Then the question begs, if these countries are giving the emission numbers, how sure are we these numbers are not inaccurate? How sure are we these numbers are not exaggerated? That in fact, in this agreement, some of these countries are being called out that they're inflating their targets. In Paris, in fact, and in the European Union agreement and the Glasgow agreement, these agreements rely on a technology termed as BECS, the Bioenergy Capture and Storage System. Friedman writes a paper called Paris 2015, Overshooting the Paris Agreement. He gets comments from scientists on this methodology. And in fact, scientists move that this method is largely experimental and is yet to scale in time to deal with the immediate risk and problems of climate change. In fact, those scientists move that it is both dangerous and quite foolish that the world pretends that we can still keep our emissions below the 1.5 degrees Celsius, and then we can say we continue to cool down the planet using speculative technology. The paper, in fact, agrees with them and moves that climate policy is failing because agreements as they are pretending that we can still avoid climate change and continue to burn fossil fuels. In fact, the climate change tracker calls out Paris that the target 2.0 degrees Celsius will have been increased by 2.15 after the post-analysis. Thirdly, esteemed bench, I mentioned people who I call them interesting. And these people are the global south, a part of the world where we also belong to. This paper moves to it that the global south, and particularly African nations, are using these frameworks as financial bargaining tools. And this is how. These countries have realized the uniqueness in them, that we are the least emitters, but we are the most vulnerable to impacts of climate change. Then they use this position to leverage for finances and negotiate and demand more financial support. In COP27, African countries, in fact, ask for over 700 billion US dollars for adaptation. What this paper is arguing is that these demands are overshadowing the proactive policies in countries and are ultimately leverage for financial burden. This paper has moved you from COP26 to COP27. Esteemed benched, allow me to put you at your last COP, which was the recent one, COP28. In the speech in one of COP28, one of the speaker, instead of calling them environmental and climate change issues, they reference them as these are environmental and climate change puzzles. In layman, puzzles are meant to be solved. Distinguished bench, I don't want to leave this podium as a lamenter of problems without giving an input on what can be recommended. On what I've just talked about of African countries and the whole global south, using climate financing as a financial bargaining tool, and in fact, it is being encouraged by Paris 2015 through the conditional targets. This paper moves. If these people have decided to use conditional targets as an abuse of the system, then it is time these agreements put conditions that when you are getting funding, you as a country must also demonstrate what you have done in your national policy strategy to combat climate change. This paper discovers that the global south is hiding behind the veil of CBDR, common but differentiated responsibility. And this paper in fact moves that if responsibility is differentiated, it does not mean that you do not have responsibility. And not to be too harsh on them, this paper moves that it is time these agreements integrate biodiversity credits to supplement the carbon credits that are existing. What biodiversity credits will move is these countries are getting financial incentives based on their efforts to conserve natural systems. So we end this handout system, or where these countries feel that there's always a need of the West to finance climate action. Secondly, on the issue of activism, this paper moves that it is time there is a basic consensus between science and policy in agreements. That we need to go back to the sequestration methods that have already proved to work than the world pretending to have exciting terminologies in agreements which science is telling us they are still in their experimental phase. Esteemed bench, I understand that we have a loophole in these agreements. These agreements are voluntary. So what does this mean? That there's a promotion of a free riding system. And if this is a free riding system, it is equating that these agreements are equally or nearing to fail. This paper moves that it is in fact agreements to stop going around and beating around issues of temperature and targets. And we know the issue that it is at hand. We are saying that let us go and tackle those concrete emissions. This paper moves that it is time agreements establish a universal carbon price rather than a focus on issues which are not the major issues at hand. And this carbon price, the paper moves that we move through a cap and trade system, which means that there will be financial pressures to sectors, both in private and in countries, to reduce their carbon emissions. And these pressures across all sectors will, rather than reliance on arbitrary targets, will motivate the reduce of carbon. On the last issue, which I brought before this panel, on speculative technologies and accountability, this paper, in fact, looks Paris to the eye and tells Paris that in the next sitting where you sit, an amendment needs to be put on that table where we have an independent verification and accountability systems of the NDCs which are being placed by these countries. The paper, in fact, moves that instead of us using speculative technologies, let us continue having our scaling up on renewable energy and carbon sequestration methods which have been proven. Esteemed bench, I started this presentation by giving an equation. It will be so wrong for me to leave this podium without giving the answer to my equation. My answer comes into my conclusion, which I call it that it is a now or never moment. And it's a question, rather a quandary to us, that it is either we take action or suffer the consequences of inaction. Thank you so much.
Thank you very much, Bobby. I'm just trying to look for extra microphones. Do you have some at the back? Yes, so we shall have a feedback session. Just a minute, I know there's one which... Yes, so we shall have a feedback session. So first, we'll just start with the audience. Is there anyone with a feedback or question?
Thank you so much. According to my opinion, that was a very good presentation. Looking at the analysis and the nexus of international law agreements that apply to Kenya in the Article 25 of the Constitution, I think, according to me, that was a very good presentation. However, there is no bulletproof presentation. That has always occurred, even in environmental projects. When the government is conducting ESIA reports and the environmental impact assessment reports, there is always a loophole. However, I expected from your presentation, because you are dealing with international agreements, I expected you to deal and focus especially on the Kyoto Protocol, on the market mechanisms provided there, especially on the international emission tradings, the CDMs, that is the clean development mechanisms, and the JIs. In your presentation, I also expected you to delve especially on the obligation strategy and the human rights strategy that was propounded in the Barcelona Attraction case. Remember, our states have a legal obligation. We have international legal obligations and also the municipal obligations that the government has to that matter. Oh, all right. All right. All right. I think for that clarification. I'm sorry for that. I'm always too fast. Nextly, I expected you to provide us with an history, an historical background, because we know that matters of climate change weren't matters that were propounded before. For example, I expected a scientific approach, like in 1896 when the Swedish scientist Arrhenius provided the first report, and also to give us an historical background, going to the Guy Stewart's calendar research in 1930, the 1988 IPCC, and also the Dr. James Hansen, director of NASA, a presentation in the US Congress. I expected you to also provide, because you mentioned the Rio Declaration 1982, I expected you to provide us with the nexus on the agreements, the UNFCCC, and also the agreements provided for in the CBDs. Lastly, it is of imperative importance to note that you didn't give, according to my point, I think you didn't dwell on the issue of speculative technologies. You didn't give a good account on that. Remember, I'm not trying to criticize the presentation. It's good, however, for purposes of learning, and also for purposes of enriching and fertilizing a presentation, I think nextly you will focus on that. Remember, lastly, I just the last one. Major emitters like USA, major emitters. In as much as we're saying that states have common but differentiated responsibilities, to my understanding, the different responsibilities stem out of the different economic capacities of these nations to align to the common goal of environmental sustenance. The principle of sustainable development was coined first in 1972 in the Stockholm Declaration and enriched and fertilized in 1987 in the Our Common Future report that was chaired by the Norwegian Prime Minister Brundtland. However, to finish on this, I think your presentation was nice. It was amazing, and congratulations for your win. I've learned something from you, and also I think that the people here have learned something from you. Thank you very much.
Thank you very much. I don't know, Bobby, if you managed to note the questions, not in a comical way, but Yeah, Bobby, just note them down. At the same time, just a request. We are giving you a chance just for one question, because remember, this was our curtain raiser. We still have more sessions coming up. You had a question? Just one question. Or a comment. Actually, it's more of a comment than question.
Good morning, everyone. Bobby, thank you for the question, for the presentation. It was a nice one. I have a question based on your argument. You said that the Global South is using the Loss and Damage Fund to seek funds from the Global North in addressing climate change. I would like to know if you're aware of some of the progress that is made in the Global South. For example, we can come close home to Kenya, where Kenya has implemented both legislative and institutional frameworks to address the crisis of climate change. Is this something or nothing to you? Thank you.
Thank you. Hi, everyone. So, Bobby, I have loved your presentation and your argument generally. However, I have a question. Your argument, you're arguing that Global South countries should, because now it's like they're taking advantage of this to source money. And your argument is that these Global South countries to be given this monies according to the efforts that they put into environmental conservation. Perhaps I would just like to know, how are these efforts going to be gauged? How are you going to determine which particular Global South country, that's my question, is making what percentage of efforts? Thank you.
Thank you very much. If a final question. Keep it short, please.
Hello, hi everyone. My name is Shamia, and I really loved the presentation by Bobby, and especially the bit on the Global South and climate, how they use it as a gamut of climate financing. I think that was a really brilliant aspect, which was different from what we've learned since time immemorial about the common but differentiated principle and that sort of thing. My question is on the methodology, which you have termed as somewhat speculative. So the question would be, is there any progress in terms of methodology that scientists have made that then means we have to move away from the one which you have termed as somewhat speculative, especially given the urgency of the problem as you're terming it? Should the international community just wait and say, scientists have not made any progress, or should we, in the very least, use the one which is being termed as, speculative within the international arena? Thank you. I think it was a brilliant presentation.
Thank you very much. Back to you, Bobby. 3 minutes to respond to the ones you captured.
Thank you. I think I'll start with the last ones, which have not been quite lengthy. There's a question on maybe a claim that I made that the Loss and Damage Fund is in fact being used as financial leverage. Just a clarification in my paper. I in fact applaud the Loss and Damage Fund, where I said that climate financing is moving from a pre-adaptation stage to a post-consequential stage. And I think it was also coupled whether I feel if legislative frameworks are not something or they're anything. In fact, in the conclusion of this paper, it terms these agreements as just a starting point. And what this paper is calling is we cannot be quite good at sitting on tables and having agreements. Then we have a challenge of going from the negotiation tables to in fact implement what we have. There was also a question on how I intend that the Global South is gauged on their efforts according to CBDR. As I mentioned, CBDR does not mean a responsibility being differentiated, does not mean it is not there. So I might not have a percentage of what I consider is enough, but what this paper says is that conditions should be there to in fact see to it that these nations are actually, so I think I equate it to something so that they can be given financing. There was also a question on methodology of science, where if my argument is that scientists are saying these technologies are speculative, so do we just wait and see? This paper moves that while these technologies are being largely experimental, there are still technologies which have proved to work. So the paper moves that the sequestration methods that have proved to work, there is no need for excitement of papers to bring terminologies in big words, and they're still largely experimental. The sequestration methods that are working, let them continue to be in effect. When these experimental are done in the experimental stages, they'll be implemented. There was quite a lengthy question on a school of thought of if to bring about nexus of agreements, the history of the history of climate change. I think one of the inefficiencies to why I have not answered that question, esteemed bench, is you'll allow me that when we are given a research paper, we are taken towards a theme. And we are encouraged as researchers to go beyond what is there. But in terms of this research paper, I think there's a place where I looked at the difference between Kyoto and Paris and moving that these agreements, though playing a foundation stage, that there's need for action to move. I think in that same comment, there was a question on speculative technologies, which I think I've also answered in my response. Thank you, esteemed members of the audience.
Yes, thank you very much. Now we'll move to the panel just to get to hear some questions that they might have. I'll start with Dr. Omondi.
Thank you so much for that insightful and also fairly rabble-rousing presentation. When I heard you, I thought to myself that we should temper our critique with a bit of reality. And this is because climate change has been characterized globally as a super wicked problem. And I always tell my students that if you compare climate change as a problem and the ozone layer depletion as a problem, then those are two species of problems. So one is a collective action problem, which is climate change, and this is what is called a super wicked problem. Whereas depletion of ozone layer is a coordination problem. So it's much easier to solve. So starting from that premise, then you now come back to the agreements. And I agree with you. The major challenge we have in environmental law is there is an asymmetry between the number of multilateral environmental agreements that have been concluded and the state of the climate, state of the environment. So that if the number of agreements concluded were commensurate to the improvement in the environment, then I think we would be very far away. But the underlying question is, why the asymmetry? And I will tell you why there's an asymmetry. A lot of these instruments are concluded on the basis of consensus. And if you look at international law is largely consensual. So if you have stringent measures in an instrument, it will hit participation. People will not just subscribe to it. We will refuse, because why should we assign ourselves onerous responsibilities which we will not meet? So what then happens? A compromise is reached. And that compromise is important because I always teach of two things: the stringency of an international agreement and participation. If you have an agreement that is extremely stringent, it means it will have very few countries being parties. And if really you have two countries being a party to a climate change agreement, what is the benefit? You need all hands on deck. And so you would rather have a watered down agreement and many people on board and a starting point for action. And the best example is Kyoto Protocol. Kyoto Protocol failed. And why did it fail? Because it segregated countries into Annex 1 and non-Annex 1. Annex 1 had very onerous obligations that they could not really measure up to. So you had withdrawals, you had non-ratifications, you had failure to commit to the second phase of commitments. And so when we came to Paris Agreement, we wanted to cure those problems. So we said, let everybody contribute. That already showed up participation. And then we said, let's have a flexible and rigid obligation. So you are allowed to declare what NDCs you want. But they should ratchet up consistently, and you should be held accountable through possibly global stock takes. So that speaks to the design and architecture and the politics of agreements. So once you understand that background, then if you now critique in terms of your research paper, it injects a dose of reality into how do we come up with these agreements and what are the challenges involved. I would also like to correct you that the Montreal Protocol on substances that deplete the ozone layer is not the first agreement of its kind. It is actually a protocol under the Vienna Convention on the ozone layer. So the Vienna Convention should be 85, the other one should be 87. Yes. And then I think the other point I want to make is sequestration is not a panacea for all climate ills, and for good reason. Imagine you have a bathtub, and if you have that bathtub, then the drain is smaller than the tap that is filling water. Take the drain to be sequestration. So the sequestration just lets out a small amount of carbon out of the atmosphere, whereas we continue pumping in quite a lot. 2, it is very expensive. 3, the efforts we are trying to invest will not be realized during our lifetime. It takes about a lifetime of about 70 years for the earth to start cooling. So we cannot really say that because this has also been a problem that has been going on for a very long time. So I think with those considerations then, you should be able to temper your research paper, because if I was a reviewer, I would give you several comments on things that you need to do. Otherwise, it's a good premise, so you just need to tweak it so that it reflects the reality, so that it does not look like something that comes from another world. I think that's all. Thank you very much.
Thank you. Thank you very much, Dr. Ade, for those insightful thoughts. Would you want to respond, or do I go to the next judge?
I think I appreciate the feedback. And in fact, it's also a call to reality that, yes, we in fact need to have a strike of a balance between reality and the recommendations we make. And I think on maybe sequestration, if we can have a compromise that scientists are telling us this carbon methodologies you're coming up with are largely experimental and they're not working. So what my paper posits is that so that we don't, even if it's a small percentage being taken away, we don't stay in this lacuna where we have experimental technologies, yet this something, though in its smallness, can work. But in fact, I could maybe better the research and maybe look at post-sequestration, what other carbon capture methods can work for us. Thank you so much.
Thank you. Thank you, Bobby. Yes, Prof? Okay. Yes. Talia? Oh, yes. Yes, Advocate Elias Ouma.
Thank you for such a wonderful presentation. And I agree with Daktari, you need to have some reality into it because global cooperation is something that has a history and it recognizes the need for us to come together to solve global issues. To speak specifically on areas that may need your attention is the need, and you mentioned it, and I think you need to do serious research on it and provide critical recommendations which are reality-based on our accountability and just the need to have our NDCs. Who measures this? Who measures our NDCs? For example, if I may pose a question, who is responsible for climate change? You realize that that answer is dependent on who you ask and how you measure carbon emissions. So is there a need to find someone who can answer these questions and is generally acceptable to all, regardless of where you come from, be it Global South or in Scandinavian countries and so on and so forth? That's number one. Number two is on, first, the research paper reminds me of the question one. I sat in the same class with Tali, our environmental law class. The question one was with regards to the reasons that led to the fall of Kyoto Protocol, and just to critique and provide solutions for the future. That was our question one, environmental law. I think even as you recognize international agreements, can you also think of making a case to do away with them? Because you made a proposition that the countries in Global South are using it as a source to get funds. And along the road, they somehow forgetting their role to contribute to measures that can circumvent this issue that affects the entire world. Can you also make a case for doing away with those global, if at all in your view, they are not making great progress? Can you make a case as a scholar to do? If you look at it in that, using that lens, you'll see the reasons, the reality why we need them. So if you just focus your research on should we do away with this, and then you juxtapose it with other international framework like in criminal law, ICC, and so on. That's all from me. Thank you.
Thank you. I think Daktari and Elias have talked substantively on the substance in climate science and the law, and I wouldn't have so much to say about that, but I can give one or two comments with respect to the research itself. My thinking in this subject, you acknowledged that the Global South, as you call it, and African countries are the lowest emitters, but they suffer the most. And you dwelt so much on the Global South. I would find that a little bit biased, and so maybe you could improve the research by looking critically if we are, the Global South are the least emitters, and the bigger problem should be the emission itself. What exactly are we looking at in terms of now dealing with the real emitters, so that we clearly understand where is the problem, so that everybody stops focusing attention on the Global South who emit very least. With respect to the question then of the financing, receiving the financing and doing nothing, I think you could back up your research with statistics and data. It would make more sense for you to make conclusions. And I got one question from the gallery where somebody wanted to know whether the countries like Kenya, for example, have taken initiatives with these measures. Because if you talk about policy, you see Kenya, we already have a lot of policies. When you talk about action, you see the government has tried to take up some few measures. And then finally, with respect to, as I understand it, almost 100% or 90% of the carbon that is in the air today that is causing the current climate crisis is what was emitted in the atmosphere during the industrialization period a century or so ago. I would understand that industrialization was necessary to move human life to the next level. And without industrialization, we would still maybe be in the Stone Age or archaic period. Now we are moving to the next stage of life, and you've seen like SpaceX the other day launched spacecraft 5 or something like that. And when you look at these processes, they involve burning a lot of carbon and emissions. So where do we strike a balance? And maybe you might need to research more so that we see where do we strike a balance between now improving or moving to the next stage of life and handling this climate change crisis? Because either way, for me, I'm still waiting for it to be made possible to go to Mars. I go there. Thank you.
Yes, thank you. Do you want to respond to those two? Then we have the final judges.
I think I take it to heart as very valuable feedback to incorporate in my research.
Thank you so much. Kimani? Okay. Yes, Prof.
Okay, thank you so much, Bobby, for your presentation. I think your paper was, you put in effort in making your paper. I've not read it, but I can feel the passion with which you present it. I know Dale has just walked out, but Alex is still here. Alex, I hope this paper is presented in the next COP, especially for the African, when the African heads of states meet and they're considering their strategies for negotiation. I hope this paper is presented to them so that they think differently about how we feel that maybe they're not really representing what we need them to be able to present at COP. The second thing I want to say is the spirit of the competition. The first person who responded to your paper from the plenary, I think also had a paper, and hajakubali matokeo. So, in the spirit of the competition, this is a competition, there'll be winners, but we're still friends, is it? Just humility, accept, and let's move forward as friends, is it? Because someone had to win, is it? Yeah, so please, let's have humility and accept that that's what the judges thought was the paper that won. On the paper itself, you talk about the global agreements. You mentioned the number. You talk about a few at the global level, but you then deep dive into the national level, and I didn't hear anything about the regional in terms of Africa-specific agreements, as well as the East African-specific agreements, if they're there, because they say that the fulcrum of implementation is always at the regional level. So are there agreements? Did you look at them? I've not looked at your paper, so I don't know. But you should have mentioned some of them. And you should also have said, okay, you've said we are failing at the national level to implement. Are we doing better at the regional level? What are the efforts that are being made at the regional level? And are there systems of accountability or possible systems of accountability at the regional level that can be used to ensure that national responsibilities or regional legal responsibilities are actually implemented? So that did not come out quite effectively. The other thing is political will. You said there's political will, but is there a degree, or is there differentiated degrees of political will? Because you talk about the political will to get into agreements, but the lack of political will to actually implement those agreements and to find solutions that actually affect the local population. So is there a degree, you didn't quite define what you understand with political will. Is the negotiations just cosmetic with no intention to fulfill them? And why is that? You should have come out to tell us why you think that we can negotiate, but we are not implementing. I felt you were a bit harsh on the African states because you did not quite bring out the global economic and financial superstructure that is the reality. And my colleague has mentioned it. The historical reality is that the countries in the West that are enjoying opulence are enjoying their opulence because they destroyed the environment to enjoy that opulence. And the demand that we are making, you called us beggars, and some of us took it to heart. Because I don't think, yes, sometimes we look like we are begging because all we talk about is money, and that's the reason why I want you to present this paper to the African heads of states and government, so that even if they're asking for money, they ask for it in a way that doesn't show us that we're just there for the money. But I think you have to take the history and understand why the Global South is looking for financing from the Global North to be able to undertake both mitigation and adaptation measures to climate change. Apart from that, I think it's a good paper. Dale, I was saying, I hope the paper is presented at the next COP during the Africa session so that both our NGOs and our heads of states and government are able to respond to it. Yes.
Thank you. Thank you so much, Professor, for that feedback and those comments. Bobby, anything?
Yes, I think, again, very valuable feedback to my research paper. On regional agreements, I actually looked at the European Union agreement, but as the paper is mostly giving strays, I think they're called Kahasho to the Global South, I could have looked at the African regional, what is happening at the regional level. I agree that there are differentiated degrees of political will, and it also spills over to the intentions of these countries to meet. And maybe a slight correction, because I'm talking of a part of the world which I'm also in. I do not see us as beggars, but I see us as leveraging our issues to get financial incentive. Maybe a sugar-coated sentence for beggars, but it was not direct. Thank you so much.
Yes, thank you so much, Bobby. Ladies and gentlemen, Bobby Diman, the best researcher for this Moot competition. Karibu. Yes, as Bobby takes his seat, we now want to move to the next round of the presentations, and we want to have the final round of the Moot competition. And the panel judges, after a rigorous round of mooting, we finally have 2 teams that made it to the finals. And we want to give them a chance to show us how they got here and why they got here in front of our whole new panel of judges. And so ladies and gentlemen, I'll give it up for team number 30 representing the applicants. Karibu team number 30 representing applicants all the way from Moi University in Eldoret. Team 30, karibuni. Please come forward. Yes, thank you. And representing the respondents, give it up for team number 20 from University of Nairobi Parklands campus. Team 20, karibuni. Thank you very much. I'll now invite my colleague Dale to just give a brief of how this moot session will proceed, and then we can start.
Thank you very much, Alex. Esteemed gallery, the two teams before you, I think, is a representation and culmination of the competition that we've had for the past 3 days. We started with the preliminary rounds on day 1. We proceeded to day 2, where we knocked out some of the teams. We remained with 20 teams which faced each other before going to the semifinals, where we had 4 teams face each other. And I'm happy to say that the 2 teams right here in front of you shall be collectively representing you and shall be the face of this particular competition. And personally, I'm really glad that you came here to support them. So in terms of the timing, we agreed that we shall give each team 35 minutes to present. In terms of rebuttal, you shall agree amongst yourself how much time you shall reserve for the rebuttals. To the judges, you'll have to agree who shall be the presiding judge. I do not want to have that mantle on me. And the presiding judge shall steer the judges in terms of answering questions, whether we shall be interjecting or whether we shall have to give them a chance to present their argument. So I'll leave it up to you to caucus so that you agree on it. As the judges caucus, I'll speak so that you won't have to hear what they're saying. Yeah, we can also use this time to just offer some prayers for the teams. I know it works. I was in some of the rooms and I could see teams hold their hands together, pray, respecting the divinity and solemnity of the moment. So, yes, I hope I'm saying something and they can have their own quiet time. yako ako nayo. We are good to go. We are waiting for the two of them, then you begin. No, okay. Yes, so if we could please take our seats, because in the next 2 minutes, this shall cease to be an auditorium at Riara University, and it shall be a court of law with the presiding judge who will now be in charge. So I think we'll wait for the two judges as I now hand over to the presiding judge.
I think let's give the two judges just a few minutes, because the bench is not quorate without them. And so anything we do might be null and void ab initio. The bench is now quorate. You may proceed to introduce the session.
Distinguished judges and esteemed audience, good morning. This is a matter before the Environment and Land Court involving Hakim Zingi and two others as the petitioners against the Ministry of Climate Change, Forestry and Conservation, and 5 others as the respondents. This session will last for 1 hour and 10 minutes. Each team will have 35 minutes to present their submissions, during which we will indicate how much time each speaker has left. We will raise our placards to indicate when each speaker has 10 minutes left, 5 minutes left, 3 minutes left, and when time is up. We request that counsels adhere to time, and we request that the audience remain silent and avoid movement out of respect for the counsel. If you must leave the room, please use the door at the back, and please maintain order and silence. I will now hand over to the judge.
Yeah, thank you. So if I had the petitioners team has 35 minutes, and of course we'll agree on the time for rebuttal. And so I would invite counsel for the petitioners to proceed. The judges will interject if necessary, but we'll try to give you as much room to present your case as we possibly can.
May it please you, my lords. My name is Kiri Vincent, counsel appearing on behalf of the petitioners. For the 35 minutes allocated to us, I shall use the first 15 minutes to address these honorable courts with regards to issue number 3 and issue number 4. For the subsequent 15 minutes, my co-counsel Ivy Musundi shall address this honorable court with regards to issue number 1 and issue number 2. That is, my co-counsel shall use the subsequent 15 minutes to address this honorable court with regards to issue number 1 and number 2. We shall reserve 5 minutes of our court time for our rebuttals. In addressing issue 3, I shall do so in 2 limbs. That one, that the respondents have failed to adhere to the procedures that have been set by the statutory instruments. And I shall also proceed to submit on the risks that it has indeed posed. And before doing so, I shall also submit on the jurisdiction of this court and all the other preliminary issues.
Counsel, just tell us the issue you are addressing.
I'll be addressing issue number 3 and issue number 4.
So vocalize it so that we are on the same page. Eh?
Okay, thank you, my lord. If that explains the nature of our submissions, I beg to proceed. On the issue of preliminary issue, this court has the requisite jurisdiction to hear and determine this matter pursuant to Article 70 and Article 162(2) of the Constitution of Hidayah. On the issue of admissibility, the issues before this court are of climate change and environment. That is concomitant to Section 13 of the Environment and Land Court Act. On the issue of locus, the petitioners before this honorable court have the locus to appear before you pursuant to Section 22 of the Constitution of Hidayah. Moving on to the substantive issues. My lords, we can no longer afford to bury our heads in the sand, for we must accept the reality that state corporations wield great power over individual citizenry. The state corporations in this instance are the statutory authorities that have been put in place. The citizens of Hidayah are the individual citizenry. They are here once again to seek justice for a violation of their rights. On the issue of procedures that the respondents have failed to adhere to, my lords, I seek solace in the case on the Biosafety Act, Section 18 of the Biosafety Act, which clearly stipulates on the procedural issues that have to be met by the respondents before introducing a new plant. And that is contained use. Section 18 stipulates that for genetically modified organisms, before being introduced, they have to go through this procedure and ensure that it has met the precautionary principle that is well set in the Article 69 as well as the Cartagena Protocol. That precautionary principle is very essential. And in that regard, I will also submit that the environmental impact assessment was not carried out whatsoever pursuant to Environmental Management and Coordination Act in this instance. My lords, pursuant to Section 6 of the Biosafety and Contained Use Regulation, it clearly stipulates that whenever genetically modified organisms are being introduced to the environment, this procedure is key. Why is it key? It is therefore very essential so that the state can have preventive measures and actions that are going to, for the unforeseen uncertainties. In this instance, pursuant to paragraph 30 of the fact pattern, the respondents introduced genetically modified maize and beans without considering this issue of contained use. In paragraph 37, they consequently, without upholding the views of the people, the concerns that they're raising, and they enroll it for the people to plant. The question that we're raising before the Honorable Court, at what stake are the people of Hidayah going to consume this and plant this without risk assessment being carried out? Where is the place of the precautionary principle? The precautionary principle, my lord, it also gives the range of alternatives that before introducing this genetically modified organism, what are the alternatives that you would have introduced? It is a humble submission that there are indeed viable alternatives other than the genetically modified organisms. My lords, the procedures are very key in environmental factors, for we do not live only for the current generation, but as well as the future generation. Much obliged, my lord. The alternatives that they ought to have explored is the use of hybrid seeds. Hybrid seeds are more natural. The way the pollination itself and the way they reproduce are equally as that of the genetically modified organisms. And this does not pose risk to the people and does not pose any risk to the environment as well. And that is the alternative that we are seeking before the Honorable Court, that the respondents failed to adhere or use this alternative to combat the food insecurity. My lord,
take me through your thought process. First, I understand the laws of Hidaya are pari materia with that of the Republic of Kenya.
Indeed.
It is your case that the Biosafety Act as is legal.
Indeed.
The Biosafety Act provides for National Biosafety Authority that allows importation, advertisement, and manufacturing of, and distribution, of GM products. To the extent that there is an act that is existent, an authority that is funded by the people of Hidaya, is it wrong for the country to use the mechanisms within the act to import, distribute, and advertise GM products?
Much obliged, my lord. Despite the fact that this Biosafety Act was introduced, it was implemented in hurriedly, it provides for the procedures. And these procedures, as I have stated, pursuant to the principle number 15 of the Rio Declaration of the precautionary principle. As much as you have the leeway to introduce the genetically modified organisms into the environment, there's a duty to assess the risks that it is going to cause. This is a new introduction. This is a new seed that is being introduced to the environment. We do not know how it is going to cause the effect and what are the veracities of the effects it is going to cause. And in that regard, it is a humble submission that this court considers, pursuant to the case of Ken Kasinga versus Daniel Kiplangat Kirui, where the Environment and Land Court at Nakuru consequently held that where the procedure that has been set in the Environmental Management and Coordination Act has failed to be adhered to, that amounts to violation of the biosafety laws.
Council, are you aware that that authority has been overturned?
Indeed.
And if it has been overturned by the Court of Appeal, can you still rely on it and the assertions that where a procedure is not complied with, then there's a presumption that, of course, a rule has been breached?
Indeed, my lord, well guided. In that regard, it is a humble submission that the procedures that were set in the Biosafety Act are set to ensure that to protect the environment, to protect the people, to protect the citizens of Hidaya. And in this regard, the risk assessment that ought to have been carried out, we do not dispute the importance of genetically modified organisms. However, the point that we are raising before the Honorable Court is, what measures did you take? What concern do you have against the people, against the lives of the people who are going to consume these products? Moving on to the risks that it has indeed caused to the environment, Section 58 of the Environment and Management and Coordination Act talks about the protection of ozone layer. My lords, the respondents before this Honorable Court are introducing genetically modified organisms in a greenhouse. What is going to be the effect of this greenhouse? A research and a report that was conducted on the impact of a greenhouse agriculture clearly states on the issues that this greenhouse is going to emanate, that is of emission of gases. And which are these gases? Through the chloral spraying and using of chemicals, the chlorofluorocarbon is going to be emitted and it will be broken down to chlorine, and that it is going to destroy the ozone layer, which protects the citizens. This is the risk that you're talking about. Now you're introducing a genetically modified organism without considering the risk that it is going to cause, and now it is going to damage the ozone layer, another risk that the people are going to face. Moving on to the issue about food, we do concur that Article 43 of the Constitution of Hidaya talks about the freedom.
It's clear from paragraph 30 that it was just an initial pilot project, the growing of the genetically modified organisms in the greenhouses. And it's also clear from paragraph 37 that the government consequently proceeded to plant genetically modified seeds, not just within the irrigation scheme, but across the country. So at what point then are we saying that the growth of the genetically modified organisms in greenhouses constitutes a violation or poses a risk to the environment in this regard, considering it's just a pilot project. And for the purpose of the clinical trials, doesn't that mean that the government anticipated the risks, evaluated them, and made sure that these seeds were safe before rolling them out to the state after conducting the clinical trials?
Much obliged, my lord. The issue that you are raising is, as much as they conducted this irrigation scheme, it is a risk assessment. After that, they have to conduct an environmental impact assessment pursuant to Section 58 of the Environment and Management and Coordination Act. This is the lapse that we are talking about. You have to also conduct the environmental impact assessment. This is pursuant to Schedule 1 of the Environmental and Management Coordination Act, which states that introduction of a new seed, you have to have assessed the impact that it is going to cause. And in this regard, while planting these seeds, they failed to adhere to these procedures, and consequently, they enrolled the planting of these genetically modified organisms as opposed to what they ought to have done.
You have mentioned that the use of greenhouse gases is going to increase greenhouse gas emissions, which is going to be problematic for the ozone layer. And what my fellow judge is asking you, this was just a pilot. It has not been expanded into the other parts of Hidayah. Does it still concern you that it's still a pilot that is still on the face of it being piloted, and so it's not yet substantively been rolled out as the way in which the government is going to be able to address its food security concerns? And then how do you balance between the right to development vis-a-vis the protection of the environment?
Much obliged, my lord. The issue about irrigation in a greenhouse, you realize that these are 20,000 acres that is being irrigated under the greenhouse effect. Now, what are the gases that are going to be emitted? It is a humble submission that this effect is going to be consequential. And in that regard, it is our submission that this court considers that the procedures that were indeed undertaken are faulty, and we proceed to submit on the risk that it is causing. On the issue of food, Article 43 of the Constitution of Hidayah clearly stipulates on the right to freedom from hunger. The respondents may tend to submit that the reason why they're introducing these genetically modified organisms is to combat food security. But the question that we also ask before this honorable court is why, or to what extent are they overlooking the reversible environmental impact that it is going to cause to the environment? Why don't you just pass through the procedures that have been set, and so to ensure that people are safe? The procedure, the introduction of these genetically modified organisms, the food that you're giving, to what effect will it have? We talk about Article 42 of the Constitution. We not only live for the current generation, but as well for the future generation. The food insecurity that is in place, as we have given an alternative, hybrid seeds would work. The introduction in that regard, we do not know the imposition of the risk that it is going to cause, and I also seek to rely on Article 70, Sub-Article 3 of the Constitution, where it clearly states that an applicant does not have to demonstrate that any person or any loss that is going to be suffered. The concept that we are raising before this court is the procedures that are faulty, and as we shall see, the procedures, as I have stated, the procedures are very crucial in this instance so that people, and also to protect the consumers for knowing what they're going to consume, and also the general rights of the citizens of Hidayah. Moving on to the second issue, my lords.
I would like to ask about the Biosafety Act. You have mentioned that it was passed without engaging the people of Hidayah. How do you want this court to address this issue? And are you going to make any substantive arguments in relation to the constitutionality of the Biosafety Act?
Thank you, my lord. In regards to the Biosafety Act that was passed it is our submission that even though it was passed hurriedly, we also do concur that it is essential for the implementation and the duty for sociological development. The point that we are raising before this court is that even though they introduced this act, they failed to adhere to the procedures that have been set.
Counsel, are you aware of the provisions of Article 118 of the Hidayah Constitution?
Yes, indeed, my lord.
Does it provide some procedure on how legislation is supposed to be enacted?
Indeed, my lord.
It provides also that Parliament is supposed to involve the people in that process. Are you going to address us on that particular issue and the criteria that we have to be able to use for us to address this particular issue?
Thank you, my lord. On the issue, seeing that my time is up, I humbly seek that the court indulge me with 2 minutes to sum up my submission.
Yeah, sum up in 2 minutes.
Indeed, we do rely on the national values and principles of governance that have been enshrined in Article 10 that include public participation, and that this act being introduced ought to have undergone these procedures, and in that regard, it is a humble submission that this court, as much as we submit relying on this act, it is our submission as well that they have failed to adhere to these procedures. And that guides me to the second limb of submission on the issue of the Attorney General being compelled to push for enactment of a law. My lord, I shall start by the right that has been violated, the right to information that is pursuant to Article 35. The right to information in this instance is the people have been denied the information to know on how they are going to combat or challenge this licensing. This has a translation effect to the right to access to justice. Right to access to justice as it is enshrined in the Constitution, as well as the effect that it is going to cause by the doctrine of laches that they have indeed been faced with. It is our humble submission that pursuant to paragraph 25, NEMA only issued a license which only communicated to the proponents of this applicant. It is our submission that with the powers that this honorable court has,
what to do or what not to do, because that is the order you are speaking from this court.
Indeed, thank you, my lord. Pursuant to Article 72B, this honorable court has the powers to compel the Attorney General to take measures. And in that regard, I also seek to rely on Article 156 of the Constitution of Hidayah, which states that the roles of the Attorney General is a principal advisor of the government, and as well as he has a tripartite role.
Counsel, does that invocation of Article 70 include doing things which the Constitution refrains up against? My colleague has asked you about separation of powers. And of course, I'm sure you know about the political question doctrine.
Indeed.
So is your argument viable that this court should issue orders compelling the AG, who should now force Parliament to enact a law that would obligate NEMA?
Indeed, my lord, on the in the case of Mitubel case versus Kenya Airports Authority, the Supreme Court of indeed, which is a binding authority before the Honorable Court, considered structural interdict not interfering with separation of powers, and that will humbly rely on the 5 elements that were set. That one, you have to show the right that has been violated, and 2, the responsibility of the public officer that is being compelled to deal with. And in that regard, we have submitted the right to information, the right to access to justice have been violated. The responsibilities of the Attorney General is enshrined in Article 156 as well as Section 5E of the Office of the Attorney General Act, which states that the Attorney General shall draft legislature proposals for the government, and the government shall include the legislature, the executive, and as well the judiciary.
Thank you, Counsel. Your time is up. So you can cede the floor to your colleague. Thank you for your submissions.
And with that, I invite the second counsel.
You may proceed, Counsel.
Thank you. May it please this honorable court, as earlier introduced, my lords, my name is Ivy Musundi, second counsel appearing for the petitioners in this matter. My lords, we stand before you today not only for justice, but for the survival and dignity of citizens who have lost everything to climate impacts. These are families who have been ripped from the very fabric of their livelihoods. These are farmers who have been pulled out of, who have been stopped from tilling the land they have tilled for generations. These are parents who have buried children because of the inaction and the actions of the government. These are entire communities that have been displaced because these are entire communities that walk around with the grant of abandonment of a government that is supposed to protect them and realize their rights. My Lord, we implore this court to act decisively and ensure that these wrongs are in fact righted, because what remains is that the government needs to be held accountable for its constitutional duty to its people, because it is a government of the people. In submitting my issues, I will show you that the government has, despite legal and constitutional mandates, has in fact failed to implement meaningful climate action, and that their half measures have resulted in displacement, destruction, and irreversible losses. That sufficing the nature of my submissions, I will beg to proceed.
Please proceed and highlight the issues that you are addressing.
Thank you. I will address issue 1 of the which is whether the government has fulfilled its obligation in putting in place adequate mitigation and adaptation measures, and secondly, whether the government has issue 2, which is whether the government has a duty to compensate victims of climate-induced displacement. In proving issue 1, my lords, I will show you that the mitigation and adaptation measures that the government claims to have put in place were in fact inadequacy. That prompts us to ask the question, what exactly is the test for adequacy? My lord, we posit before this court that the preamble of the UNFCCC and the Paris Agreement in Section 4.1 places an obligation on the government to put in place sustainable mitigation and adaptation measures towards combating climate change. Further, we posit before this court that adequate measures must contribute to the 1.5 degrees Celsius global warming goal, and without necessarily undermining progress. Further, we posit before this court that adaptation should include risk-informed planning, which the government failed to incorporate in this case. Secondly, the second test for adequacy would be proportionality. In the case of Patrick Musimba versus the National Assembly of 2015, the court emphasized the need to balance public interest with individual rights, and that these measures that are put by the government should achieve their goals without necessarily causing harm. So proportionality. And the last test would be effectiveness. Did the measures achieve their intended outcomes? We posit before this court that if, in the event that we are able to prove to you that these measures that were put in place did not in fact achieve their intended outcomes, then we prove that they are inadequate.
On the basis of either the constitution of Hidayah or the legal instruments of Hidayah, can you tell us what is the sources of these obligations that you want this court to find that the government of Hidayah has not been able to put in place?
Much obliged, my lord. My lord, Article 42, 43 of the Constitution of Hidayah, read together with Article 69 of the Constitution of Hidayah, places obligations on the state or with regards to mitigating climate impacts in this case. I will now proceed to show you that the inconsistencies of the government's actions with the existing policies did prove a lack of coherence.
Council, what's the nature and the content of these obligations that you want us to be able to find that has been violated by the government of Hidayah?
These are environmental obligations.
What's the content of the obligations?
I will seek the indulgence of the court in that matter.
Please proceed.
Thank you. My Lord, I will now show you that the inconsistencies of the government's actions with existing policies prove a lack of coherent strategies towards climate impact, which in fact show that the government has failed to put in place mitigation and adaptation measures. We posit before this court that the lack of risk-informed planning in the building of Lakeview Dam, even though the building of the dam was meant to benefit the people of Babadea, the lack of risk-informed planning which led the government to continue with the building of this dam, even though recommendations had been given and reports had been made to show the risk of this dam collapsing, even from the onset, shows a lack of coherent strategy in this regard. My Lord, the building of Babadea Road through forested areas is inconsistent with the government's commitment to reforestate the country of Hidayah in a bid to mitigate climate change. It is unjustified to say you're going to plant 15,000 trees and to encourage people to plant 15,000 trees, and in the spirit of building Babadea Road, you clear forestation areas to achieve this. We think it is inconsistent and it is extremely problematic. We also posit before this case that the non-regression principle, we posit before this case, before this court, that the non-regression principle in environmental matters states that Yes, my Lord, fact paragraph 27 does in fact posit that the construction of Babadea Road was across a national park, which is considered forestation area.
A national park is considered a forestation area?
It is considered an area
and
of...
even so, paragraph 5 of the fact pattern, the country's economy is largely dependent on tourism. So why would we not construct a road in a national park if that is to promote tourism?
My Lord, we recognize the government's duty to, in fact, balance, to be able to balance environmental obligations with economic obligations. But in this case, my Lord, we posit that the soil around Babadea region, around where the road was built, which is parallel to where the dam was built, was, through reports, was shown to be unstable. So the building of this road and the building of the dam was said to have, there was risk that was posited of these two projects making the soil unstable. The building of the continuance of the building of these two projects, therefore, and the effects that later happened due to soil erosion and increased sedimentation within Lakeview Dam, then lead us to the conclusion that the actions that were...
I follow that. Sorry for cutting it short. My final question on that is, on issue 1, we are looking at adequacy of the adaptation and mitigation measures. You are dwelling on the 2 accidents that happened. Actually, 1 accident of the collapse of the river. Paragraph 31 uses the word, paragraph 43, which inadvertently, meaning it was accidental. it was not deliberate, that the construction of the road should lead to siltation that might have led to the collapse of the river. Why should we ignore the fact that the government has submitted commitments, NDC, the government has put policy measures in place, acts, the government has adopted a fund, the government has started a 15 billion tree growing, the government has in fact gone ahead to gazette a holiday so that it encourages citizen participation in tree planting. Why should we ignore all these measures and only concentrate on an accident that happened, which is regrettable?
And just to follow up on that, is it the petitioner's contention that only projects without any risks are the projects to be implemented?
Much obliged, my lords. We posit before this court that we recognize the efforts that the government has put in place. The argument I am advancing before this court is that even though, as rightfully put, the government has put in place a lot of policies, as we have mentioned, the reforestation program, the implementation of Mazingira Day. But you see, my lords, this all becomes inconsequential when the government's actions are inconsistent with said policies. As I will show you in my next limb of argumentation, the government has a tendency of procedurally doing things. I will answer also the question of high-risk projects in the sense that we recognize that we cannot ignore all projects that are high risk. But to the extent that you consistently do this and it consistently results to harm, my lord, if you're doing something the same way, then it means you need to if you're doing something the same way and it results in harm, then maybe you need to change the way you do things. There is no point for you to have procedural measures and having risk assessments within your policies if you're not going to make risk-informed decisions. And we think that is a fault on the part of the government. I will proceed to my next limb of argumentation, which is the implementation was procedurally flawed, which inadvertently makes the mitigation and adaptation measures inadequate. We submit before this court that the case of BAT versus Cabinet Secretary of Ministry of Health of 2019 posits that meaningful public participation is essential for government action to be lawful. And the lack of public participation in this...
Council, because you have very little time, let's hear you on the second issue very quickly, because I think you're almost out of time.
Much obliged, my lord. I will proceed to my next limb, my second issue, which is the issue of whether the government is obligated to provide compensation. We posit before this government that the IDPs Act places an obligation on the government to prevent, protect, and assist internally displaced persons. That is in Section 15. Section 2 further describes who an internally displaced person is, and we posit before this court that just by that measure alone, the government is in fact...
Council, one central question. Compensation is based on evidence. Is that correct?
Yes.
Have you filed any report attributing the loss suffered to climate change before this court?
Pardon your question, please.
Have you, in your evidence, filed any report that attributes the events suffered to climate change?
My lord, the events that happened are in fact attributed to climate change.
But is there evidence to that effect on record?
In the fact pattern, the heavy rainfall that came towards Hidaya were posited to be as an effect of were posited to be an impact of climate change. But we will also add that the harms that were suffered by the people of Babadea were not entirely due to the climate impacts. We posit that the government also had a hand in, was also an agent in the perpetration of harm. I will present before this.
Council, what's your understanding of the principle of constitutional avoidance? And on the basis of the doctrine of constitutional avoidance, don't you think that this limb of the case should be presented in court in a civil process as a tort of negligence?
We submit this before this court that this cannot be, in fact, cannot be entirely dealt with as a tort of negligence, because there are fundamental rights that have been violated that this court needs to address, that the lives of people have been lost, that there have been loss of housing and adequate water. Seeing as my time is up, I will request 1 minute to wrap up my submissions.
Yeah, 1 minute to wrap up.
Thank you, my lord. In conclusion, the facts show a pattern of exclusion and inadequate response on the part of the government. The state's constraints are not justifiable as resource constraints or unintended consequences, because, my lord, there have been funds that were allocated towards this, and we posit that the government did not use these funds appropriately. My lord, we posit that the actions of the government represent a breach in human dignity and environmental integrity and public trust, and we pray this court that, in accordance to Article 70 of the Constitution of Kenya, to declare the state in breach of its duty, to order adequate compensation for the victims of climate-induced displacement, to discontinue the implementation of GMO. Thank you.
Thank you, Council. I invite the Respondents' Council. Council, your time is running. You may proceed.
The table below is very slight, but I'll proceed. Presiding Judge, honorable members of the bench, may it please this honorable court, my name is Ayaga Max Lembila. For the respondents, alongside Mr. Kelvin Nyaribo, in the present matter. If it pleases the court, I will take the first 18 minutes of this court's time to dispense on the merits of the first and third issues, whereas Mr. Kelvin Nyaribo will take the subsequent 17 minutes of this court's time to address the second and fourth issues. If that suffices as the outline of our submissions, I beg permission to proceed.
You may proceed, Counsel.
Honorable members of the bench, the petition before you here today will have you believe that the respondents are not only negligent, but in utter violation of their environmental obligations. The petitioner has painted a picture of the same. I seek to debunk these assertions and paint a rather clearer picture of a state that is in full realization of its obligation. On the first issue, as with regards to the fulfillment of the government's legal obligation in addressing climate change through providing adequate adaptation measures, I advance two arguments. First is that we have implemented these adaptation measures, and second...
Counsel, are you conceding jurisdiction?
Yes, we do not intend to dispute the jurisdiction of this court or any preliminary issues.
Okay, proceed.
Two arguments, my lords. First is on the implementation of the adaptation policy initiatives, and second is that environmental and climate change obligations are progressive in nature. On the first limb, Article 4 of the United Nations Framework on Climate Change, as read together with Article 4 of the Paris Agreement, commits countries to submit nationally determined contributions, updated and put in measures to combat climate change. Now, contrary to what the respondent has submitted, we have actually submitted nationally determined contribution which seek in paragraph 7 to reduce our carbon emissions by 32%. However, we do take note of the question of retrogressiveness that has been advanced by the petitioner as with regards the greenhouses. However, we seek to respond as follows. First, on the question of greenhouses, the petitioner has not presented any scientific evidence on how greenhouses in and out of themselves can lead to greenhouse emissions. And it is the position of the respondents that there is absolutely no research that supports that position, that greenhouses in and out of themselves can lead to emissions. And the only way greenhouses can lead to emissions is when the fuels used are fossil fuels.
Council, you've said your obligations are progressive in nature.
Yes.
Would you please elaborate to the court what you understand by obligations that are progressive? And the second thing, you've considered that the greenhouse gas problem is retrogressive.
Yeah.
How would you want us to determine, or which criteria do you want this course to use to determine whether that retrogressive measure is justifiable or is not justifiable?
My Lord, in response to first your final question, the position I am making is that the case by the petitioner is that that move is retrogressive. And our position is that the evidence they have given to that end is unreliable, and there is absolutely no research that supports that position, that greenhouses in and out of themselves are able to lead to greenhouse emissions. And that is why I was presenting before this court the specific research that the only way greenhouses can lead to greenhouse emissions is when they are supported by fossil fuels. And even if in their rejoinder, the petitioners are to argue that we are pursuing this project with non-renewable sources of energy, paragraph 8 and 9 of the compromise will beat this very argument, because as part of the climate smart agriculture, the government is employing the use of renewable sources of energy. Now, in turn to the question of progressive realization.
Council, before progressive realization on these greenhouses, is it correct for you to avert that there is no research that greenhouses in themselves are not harmful to the environment and the climate?
Yes, my Lord, and if I may respond to your question, this is how greenhouses work. The greenhouses, there is heat from sun, and then the greenhouse prevents the heat from going outside, and which leads to the warming of the greenhouse conditions. And it is that similar situation that we have in the atmosphere when then the solar energy that comes from the sun is absorbed by the greenhouse gases, the CO2, methane, and all others, which then radiate and prevent the energy from going back. It causes what is called the greenhouse effect. So the greenhouse gases stem from the greenhouse effect. It's not a literal sense then that because it's called a greenhouse, then it emits greenhouses. And that is the position, my Lord, if you look at the United Nations Framework on Climate Change Explainer, also if you look at the Intergovernmental Panel on Climate Change on the same.
I follow that,
yes,
and I agree with you. The concern would be the materials that make greenhouses themselves.
Yeah.
And a research by Harvard titled From Warming to Warming, the environmental impact of greenhouses, says that China and South Korea have had a very big problem with greenhouse materials being made of plastics. The plastics break into microplastics, end up polluting water and soil. And that in itself becomes detrimental to the environment and to the climate generally. So can you address that aspect of the material that is used to make the greenhouses?
Yeah. My Lord, if I may combine your question to the question by the learned judge as with regards to whether we have a justifiability to that specific measure if the court is convinced that it's retrogressive with your argument. Now, the doctrine of progressive realization allows some sense of retrogressiveness in exceptional circumstances. Now, in the exceptional circumstances, we submit that the greenhouse project is being introduced for clinical field trials in paragraph 30 for GMOs. The importance of that is that we are using the greenhouses to prevent gene flow. And I ask this court, as it retires to make its determination, to be guided persuasively by the European Food and Safety Authority regulations of 2021, also the biosafety considerations of GMOs of 2018 by the International Center of Genetic Engineering, which posit that when it comes to clinical field trials, greenhouses are the best conditions to ensure there is no gene flow. So in the present case, in this clinical field trial, which is a project as a risk assessment, we need to prevent any form of gene flow. And that is why we are using greenhouses. We are not necessarily using greenhouses to grow GMOs for the rest of the Hidayaan life that is going to be there, but rather it is specifically for this clinical field trial. If that suffices as the response, I wish to proceed to my arguments. Now, another pointer as with regards to the retrogressiveness that has been alluded by the respondent is with regards to the Barbadea Road construction, which holistically reading of paragraph 43 then would invoke partial liability on the state. Now, we do note that the omissions specifically by the respondent fall below the what the respondent argues as environmental standards. However, we do note of that concern, and we ask this court specifically to be guided by the decision persuasively of the International Court of Justice in Argentina versus Uruguay, as with regards the question of the omissions by Uruguay on the construction of a road in River Uruguay. And the court was of the view that since these omissions specifically fall below the international standards, the court issued an order that the respondent, which was Uruguay, be allowed time to revert, first of all, compensate the victims, and second, to ensure that their actions meet the standards. And the issue of compensation, we do not will be handled by co-agent, and we do not that we will be compensating the victims, that is one, and two, we intend to raise that specific standard to meet the international standard.
Counsel, I follow your argument.
Yes.
However, your reliance on an international authority that justifies, disregard of procedure for the purposes of implementation of project is disingenuous to the extent that it disregards existing local authority that lead to the nullification of the implementation of projects when there is disregard to municipal law. Yes. It is clear from paragraph 23 that there is an environmental impact assessment that is done, warning the state of its the risks in implementation of the project, but the states still go ahead and implement this project. It is also clear that the public participation process is not conducted in the manner that is required by local legislation. So I'd invite the respondents to address us on the standards set by municipal law in relation to the implementation of such projects, reflecting on local and indigenous jurisprudence in respect of the same, and proceed to then answer whether the implementation of these projects in disregard of these procedures would then constitute a violation of the rights alleged by the petitioners or not.
My Lord, in response to your question, first, my reliance on the International Court of Justice jurisprudence is not really to seek to elevate the omission that was made by the respondent. However, actually, in fact, in the Uruguay case, it was a question of procedural impropriety. And the reason I am relying on that case is that we do not, and we do acknowledge there was an omission in municipal law on our side on implementing those mitigation measures. That is why we're asking this court to order an appropriate relief to that end, and the same will be canvassed, if I may conclude that and respond to.
But essentially admitting that there was disregard to procedure.
We do note that on that very issue of the Babadea Road, there is an omission on the part of the respondent, which to that end led to the collapse of the dam partially.
Okay,
We do
thank
not. Yes. Finally, in concluding that specific issues, we do note that in as much as the petitioners allege that we have fulfilled the adequacy or lack of it of the adaptation measures theoretically, we submit that we have actually fulfilled part of them practically. And specifically, if you look at paragraph 18, paragraph 17, and paragraph 19, the government first has put up initiatives to plant trees. And specifically, look at paragraph 20. If referring to the National Climate Change Adaptation Plan at page 35, under the proposed sectoral adaptation actions, you will note that there are short-term adaptation measures and medium-term adaptation measures. Medium-term adaptation measures take 3 to 5 years. Lord, if you look at paragraph 20,
In the interest of time, I would like you to address, to address one issue the petitioners raised as to the lawfulness of construction of a road in a national park.
As to the lawfulness of constructing
a road like the Babadea Road through the national park.
My Lord, as with regards to that question, we do take note of the fact, as you addressed, the issue of balancing economic sustainability and environmental protection, as with regards to whether we should proceed with the roads and also ensure that we have we achieve environmental sustainability. But on the same, we do submit that the specific issue, as with regards to the construction specifically, the same was to promote economic sustainability in Hidaya.
What I'm trying to understand is it lawful with respect to when you're balancing interests to construct the nature and type of road like the Babadea Road in a national park, considering that the ecosystem in the national park forms part and parcel of the environment, which also contributes to the entire ecosystem in climate change. So as a country, is it lawful for you to construct, let's say, a fully tarmacked road in a national park?
As with regards to that question, as long as the mitigation measures are put in place, then the same may be possible. In case they are not able to, if there are mitigation measures to the risks that have been raised as with regards to that specific project. Yes.
Okay, thank you.
Finally, in concluding that issue, reverting back to my arguments, you will realize that already in a span of 1 year, we have implemented county climate funds. My Lord, the petitioner has raised so many issues, but if it is that specific issue, my Lord, this court needs to take note that in less than 1 year, we have already implemented that. I will now turn to the issue. Yeah.
5 out of 47.
My Lord,
statistically.
Yes, that is the point I was trying to make, that we've done that in less than a year. And we are required to do that in 5 years. So by the time we get to 5 years, we will have achieved the same. My Lord, if you do the math, then if it's 5 and it's progressive, then by the time we get to 5 years, we will be there. And we ask this court to give us margin of appreciation on the same.
Proceed.
Thank you. As with regards to the question of introduction of GMOs, I just seek to respond to the issues raised. And summarily, it's with regards to the precautionary principle. Now, I seek to ask this court that in as much as the laws of Kenya are similar to the laws of Hidaya, the facts are not. And if you look at paragraph 30, then the bill came after the clinical trials. So therefore then, the clinical trials will be guided by the international laws that were there at that time. And in response to the question of precautionary principle, this very court noted first in 2015 in Kenya small-scale farmers, versus CS of Education, again in 2023 by the LSK versus Attorney General, that then the precautionary principle ought to apply. And there are 4 parameters to the precautionary principle. The first is putting preventive measures. The second is exploring alternatives. And the third is the question of public participation. I will start with the preventive measures, which were distilled to include risk assessments. And that is the contention in the present case, whether the risk assessment conducted was sufficient. And the respondent alludes to the question of environmental impact assessment. Now, in the present case, we want to submit before this court that the clinical field trials that we conducted in the greenhouses was sufficient. First, the definition of a clinical field trial refers to an experimental study conducted under controlled conditions in an actual field or a greenhouse or any controlled conditions laboratory to evaluate the effects and efficacy of GMOs on human, crop, and surrounding ecosystem. And again, the best practice, if you look at regulation number EC, number 1829 of 2003, the European Union was of the view that controlled experiments outside a lab setting, outside, and the point that I want this court to note is outside a lab setting, where GMOs are planted in a natural environment condition that are controlled, is enough sufficient for the same. Again, while taking note that this same question has not really been handled by any Kenyan case, I seek to refer this court on two authorities.
Counsel, just in the interest of time, I'd like to lead you to paragraph 32,
yes,
where it is clear that there is an amendment of the Seed and Plant Varieties Act to include sections which prohibited the sale of uncertified seeds and unregistered seeds.
Yes.
What exactly is the purpose that is being pursued by such a prohibition?
Much obliged. As with regards to the certification, again, it is just to solve the fears by the petitioner. The fear being, seeing that my time is up, I'd request just...
We'll give you 2 minutes.
Yes, yes.
And while at it, I want to piggyback my question on the question by the Honorable Judge. And in their opening statement, the petitioner said that if you look at the actions taken by the government, they are calculated to disenfranchise farmers. So then, what would be the rationale in insisting that when, in prohibiting uncertified seeds and unregistered seeds, knowing that this is the bulk of what the indigenous community can access?
Starting with the learned judge's question on why we are certifying the seeds. Now, one of the fears that are being raised by the petitioner is the question of gene flow, that there is a risk of contamination of indigenous seeds. Now, we are introducing GMOs, and there is that risk. So the precautionary principle then calls upon us to apply a preventive measure. The preventive measure then is to ensure that the seeds that are moving from person X, farmer X to farmer Y are not contaminated. And that is now where the certification comes into place, that we are certifying this specific seed that is moving, not the seed that is being used, the seed that is moving, so that the seed that moves from farmer X to farmer Y is not contaminated. And that is specifically to solve the fears. Yes, yeah.
To prohibit the sale of uncertified
Yes.
seeds and unregistered seeds.
Yes.
A farmer in the country of Hidaya, in one of the counties,
Yes, yes, my lord,
has seeds that they have planted since they inherited the land from their great-grandfather.
Yes, my lord.
They sell these seeds to their next-door neighbor.
Yes.
Are they uncertified or certified seeds?
They are uncertified seeds.
Is that a crime under the Act?
My lord, it is if the same are uncertified. And the point I'm trying to make here, my lord, is that there are GMOs that are being introduced. Then we are being called to take care of the fears that are being raised. One of the fears here is contamination of these seeds. Now, we are preventing the seeds that may have been contaminated by farmer X not to be sold to farmer Y and end up contaminating the seeds of farmer Y. So in between, there is the registration and certification of these seeds to ensure that this seed that is moving is very much certified for the same.
Counsel, with the permission of the lead judge.
Yes, yes.
If you look at what you're introducing as the Seed and Plant Varieties Act, vis-a-vis Article 11, Sub-Article 2, Part B, Sub-Article 3, Part B, is your actions constitutional? according to your own constitution?
My Lord, Article 11 requires that we protect and safeguard the cultural, including indigenous, which will then involve the indigenous seeds. My Lord, on the same, we submit that we are not, to some extent, that is Article 11.3b, as with regards to the seed ownership and indigenous. No, my Lord, we are not, in any case, unconstitutional, because what we are doing is actually constitutional, because in Article 69 we are required to eliminate activities that may pose danger. Then that elimination is then by ensuring that the laws that are there are able to safeguard the same. And in conclusion, I cede floor to co-counsel and ask this court to rule in the favor of the respondent. Thank you, my Lord.
Thank you, counsel. So you may proceed.
Distinguished members of the bench, honorable members of the court, good afternoon. And may it please the court, my name is Kelvin Nyaribo, as earlier introduced, appearing as second counsel for the respondents. I shall use the 17 minutes allotted to me to dispense with the second and the fourth issues that are pegged for determination. Your honors, we find ourselves in a battle between the immense forces of nature and the reach of governance. The petitioners seek to hold the state accountable for every flood, for every catastrophe. And this is as though human hands could leash the wilderness or the wildness of climate. But your honors, the government of Hidaya, like a vigilant steward, has done its utmost within its means. Now turning to our substantive responses to the second issue. It is the position of the respondents that the government has met its legal obligation to compensate the victims of displacement resulting from the climate-induced disaster. And we front one key argument that the government's support to the victims for relocation was reasonable despite limited resource allocation. Your honors, as has been aptly pointed out by my co-counsel, the reason as to our legal obligation to compensate has been provided under...
Counsel, yes. The state has obligations to protect its citizens. The obligations vary from the obligation to respect, protect, promote, and fulfill. If you're looking at the obligation to protect, does your client have obligation to protect its citizens from reasonably foreseeable climate catastrophes? And how have you been able to meet that obligation?
Much obliged, Your Honor, and it is indeed the position of the respondents that they have an obligation to protect from internal displacement. And you will note, Your Honor, from paragraph 20, in the construction of the Lakeview Dam in paragraph 21, the dam itself was meant to act as a reservoir during flooding. And it is this same flooding that is what has become the calamity that we are facing. So in that respect, the government in itself had foreseen the impacts of floods, and to be able to reduce the effects of these floods, put up the reservoir or the dam to act as a reservoir. Turning and reverting to my arguments, the reason that was stated by the second counsel for the petitioners was that the Lakeview Dam had potential risks, and therefore it means we are liable in that particular aspect to being, we are held liable because of that. You will note, Your Honor, that regulation rather, I beg your pardon, Regulation 16 of the Environmental Impact Assessment and Audit Regulations of 2003 require that an environmental study contains the anticipated impacts of the project and the scale of the impacts. So a project having potential risks does not automatically mean that you should go and leave that particular project as it is. What the government is required to do under Regulation 18(1)K is to put mitigation measures in respect to those potential risks. And the petitioners have not cited any factual basis to make that argument.
I would be disturbed if we go that line, because your first argument, you admitted that indeed the government had the obligation to compensate, and the question was that the 10,000 given was reasonable. Was that your submission?
Much obliged, Your Honor. Indeed, we are taking liability as far as the Babadea Road construction project is concerned, because under paragraph 27, there were soil mitigation measures that were not in place. The response I was giving was in response to the query that had been raised by the second counsel for the petitioners.
Good. So I would like us to stay true now to the question of compensation. Now that you have admitted liability, then the question just becomes the criteria that we should use to assess whether 10,000 figure given is reasonable or not. So I would love to understand what is that criteria.
End by saying that the petitioners did not make any submissions in relation to the mitigation measures put in by the government, and you shifting the burden to the petitioners to make that if you put in place mitigation measures, tell us what mitigation measures you put in place. Not ask the petitioners to say that they did not put in mitigation. Who has the burden? Thank you.
Much obliged, Your Honor. To begin with the first question on whether the 10,000 is commensurate, you'll note that under paragraph 48 of the record, the 10,000 was meant to help the citizens that were displaced to be able to relocate. Now the question that Principle 29.2 of the United Nations Guiding Principles on Internal Displacement provides, that compensation amounts to where the citizens left their properties behind and they are not able to recover it, the competent authorities should provide or assist those particular citizens to be able to get appropriate compensation that is commensurate to the damage that was caused. In this case, Your Honor, the government has only been able, because of its resource constraint, to provide 10,000. Now, for how then is the government as competent authorities trying to assist? You will note that under paragraph 41 of the record, the president of Hidayah has asked for international assistance. And Your Honor, asking for international assistance is an obligation that the state has under section 11(6) of the Prevention, Protection, and Assistance to Internally Displaced Persons.
And then I follow up on that line of submission so that we don't lose this question.
Much obliged, Your Honor. It is well established that he who alleges must assert. Additionally, Your Honors, in the Supreme Court case of Raila Odinga versus IEBC and others, petition number 5 of 2013, the court was responding to what the petitioners are required to address when they are stating that there is a procedural irregularity on the government. And the court pointed out the Latin principle, omnia praesumtu rite esse action, which means all acts are presumed to have been done rightfully and regularly. So the petitioner must set out by raising firm and credible evidence of the public authority's departure from the prescription of the law. That was not done by the petitioners.
So, Counsel, are you then saying you're not admitting to liability? Because the first thing you told us is that you are admitting to liability. And it was also co-counsel submission that you admit that there are procedures that are not followed in the implementation of this program. So are you departing wholly from that submission? And secondly, once you admit liability, aren't you then required to provide compensation that is akin to reparations? And are you then submitting that the 10,000 is commensurate reparations, actually, not just a stipend being given to aid the individuals affected, but adequate reparation for the harm suffered to these individuals, considering there are individuals that are dead and others that are displaced? Thank you.
Much obliged, Your Honor. the first question I was raising in terms of the query you raised that they are supposed, when we, the people supposed to show that we put mitigation measures in terms of the Lakeview Dam collapse, in terms of putting the environmental, social, and impact assessment risks, which they pointed out that we did not address. The liability we are taking is in terms of the Barbadea Road construction project. Additionally, on the question of the 10,000 shillings, well, the court has established in the case, which is the Court of Appeal case, which is as is binding before this court, in the case of Board of Trustees of the Anglican Church Diocese of Marsabit versus the NIA and 3 others in 2018, the court stated that the quantum of damages must be reasonable based on the circumstances of each case. Now let us look at the factual basis to show the circumstances in our case. You will note that the Republic of Hidayah is a developing country. In addition, the resources that it relies on is that the country's economy is largely dependent on rain-fed agriculture, tourism, and natural resources. We are told that these particular sectors of the economy are highly susceptible to effects of climate change. And as seen in paragraph 6 of the record, the government is already facing this already facing the greatest brunt of these particular effects. And the petitioners may wish to rely on the fact that we received 291 million shillings, or 291 USD million shillings for the FLOCA program. You'll note, Your Honors, that we received this particular fund in 2021. And this particular fund has been used to strengthen the climate resilience of the country. It built projects that were to address climate risks. Your Honors, however, when you look at paragraph 38 of the record, is that Hidayah has been facing a 5-year drought. And immediately that particular drought ended, we are welcomed by another crisis. That is the floods that have been unprecedented and, according to paragraph 38, have never been seen since the turn of a millennium, Your Honors. A millennium is a period of 1,000 years. How do you place an obligation on the state to be able to predict, or as far as something that has never been seen in a period of 1,000 years? Your Honors, therefore, the obligation we are making is that under section 11.6 of the Prevention, Protection, and Assistance to Internally Displaced Persons, which I shall henceforth refer to as the IDP Act, requires that where the resources of the state are inadequate, they can seek international assistance. So by the President under paragraph 41, seeking for international assistance is just meeting the legal obligation that even our local statutes themselves acknowledge that we may be faced with resource constraints.
Clearly, you have admitted that issue. You have admitted liability. You have also admitted that the victims are entitled to compensation. That one you have purely admitted. Then why are we belaboring on this issue? Instead of this court giving an order, it might be a structural interdict that you look for funds, you report back to this court in 6 months' time, how much funds you've gotten, and how much funds you've given to the people.
Much obliged, Your Honor. And that order does not prejudice our case in any way. Because when you look at the question that has been framed before this court on question 2 is that whether the government is legally obligated to compensate the victims of displacement. And we are seeking to answer the question that indeed we have that legal obligation.
So you have admitted to the issue?
Yes, we are responding to the question that has been raised.
If you admitted to the issue, you can just do the next issue.
I was actually marking the end of that particular issue to turn to the 4th issue, if there is no other queries on the same.
Yeah, proceed. I wanted to ask you to proceed with the 4th issue.
Much obliged, Your Honors. Turning to the 4th issue, it is the position of the respondent that the court should not issue an order compelling the Attorney General to enact a law. And we front 2 key limbs of argument on this matter in response to the queries that have been raised by the petitioners. One is that the Attorney General does not have the powers to push for enactment of laws, and that 2, a legal framework already exists on the requirement for NEMA to be obligated to communicate its decision. Your Honor, you will note that the first counsel for the petitioners pointed out that under Article 156 of the Constitution, the Attorney General is the principal legal advisor to the government, and therefore the court can just make that particular order for there to be enactment of a legislation. Your Honor, we wish to say that that is a wrong interpretation because you are advising on legal issues. And you'll note, Your Honor, that the High Court, in the case of Republic versus Town Clerk, Kisumu Municipality, ex parte, East African Engineering Consultants in 2007, was pointing out on some of the aspects on which the court would take to give an order of mandamus. And the third step was that this is where the public duty has been shown to exist, but it will, however, not compel its performance or exercise of its discretion in a particular manner. So, even if the court is persuaded by the fact that, I request to see that again, much obliged. Even if the court is, even if the court is persuaded by the fact that the Attorney General can make that particular, as that particular duty, the court cannot compel a public duty that is discretionary to be performed in a particular manner. Additionally, Your Honors, Justice Talley asked the question, or posed the question to the petitioners on the issue of separation of powers. And in the case of Martin Wambora, the county government of Embu versus the Speaker County Assembly of Embu and 4 others, which is the Court of Appeal case, which is therefore binding before this court, the court elaborated its jurisdiction to determine matters that are affecting legislative or executive. And it acknowledged that the Constitution...
Counsel, if that is your argument,
yes,
this court can give other reliefs that it deems fit. So what would be an appropriate relief in lieu of the relief that you impugn?
Much obliged, Your Honor. To respond to your question, allow me to rely on the High Court case of Republic versus JQuat ex parte Elijah Kamau Mwangi in 2021. And the court was of the opinion that the court will not grant mandamus where there is an alternative remedy available to the applicant. Then the question is, what is this other alternative remedy that the petitioner can seek? Article 119 of the Constitution provides that every citizen has the right to petition Parliament to perform its function, whether it's to seek for them to enact a specific law or make amendments to it. So the order that is being sought before this court cannot actually be made because there is already another existing alternative remedy. And that now turns me to my second limb of argument on that same issue. And it is the question of a legal framework already exists on the requirement for NEMA's communication. And the respondents wish to rely on Regulation 29 of the Environmental Impact Assessment and Audit Regulation of 2003. And Your Honors, it provides that information, documents and information that is submitted to NEMA in relation to an environmental impact assessment license, together with NEMA's decision and the reasons thereof, be made available to the public. It is the same question that the petitioners are asking this court to make, that NEMA to be obligated to communicate its decision. There is already an existing legal framework that requires the same.
That Regulation 29 is with respect to decisions on environmental impact assessment reports and when they are done. It is possible that NEMA can approve an environmental impact assessment report, however, might not end up granting a license for other reasons, for example, because there are many approvals to be sought before a license is granted. So don't you think that framework of Regulation 29 does not address the matter in issue?
I wish for clarity, it does not address what specifically?
The question that the petitioners are asking for, the need to have a specific legislation.
That requires NEMA to communicate its decision.
Yes, on licensing. You are citing Regulation 29.
Yes.
Regulation 29 is communication of decisions on environmental impact assessments. They are asking for a framework on communication of decisions on licensing. They're not one and the same thing.
Much obliged, Your Honor. When this court makes, I see that my time is up. I seek for a minute to respond to your question.
Yeah, wrap up.
Much obliged. When this court retires to make its ruling, a deliberate and thorough assessment of the current legal framework that guides the whole decision about licenses, you'll come to the inevitable realization that when a project proponent has been issued with an environmental impact license, an environmental impact assessment license, it gives them the go-ahead to now begin the project. Because you'll note that when the NEMA has the power to actually revoke it. So it means that this environmental impact assessment license is actually what gives you the go-ahead to start conducting the project that you asked for.
Council, in 1 minute, you said there's a regulation 29, that requires NEMA to provide information. You want this court to retire to make a decision. Can we make a decision that there's a regulation in place which you have violated, and so we should make your government responsible for those violations for failing to provide that information on time to the communities for them to be able to access justice?
Much obliged, Your Honor, and I duly note your concern, which has also been elucidated in paragraph 25, is that the citizens sought for a response, but they did not receive it in a timely manner. Actually, Your Honor, the petitioners still have another alternative remedy. When you look at the Access to Information Act under Section 14, petitioners can seek audience before the Commission on Administrative Justice to get, when they are aggrieved by the response in terms of the time frame that an authority has taken to respond to that question. Therefore, it is the position of the respondents that the court should dismiss that particular prayer. Allow me then to make our conclusion.
Very fast, in 1 minute or 30 seconds.
Relying on our prayers as is in our written submissions, Your Honors, the deluge of 2024 was nature's fury unleashed, and the government was not in control. But in the face of this calamity, the state did not falter. It acted promptly and with ease to alleviate the suffering of the citizens. It is the position of the respondent that this court see that in a world where natural disasters outgo the best efforts of the government, that this court should strike a balance. It is our prayer that when you retire, you may rule in our favor. I am most obliged.
Thank you very much, Counsel. Rebuttal.
Thank you, my lord. For the 5 minutes that we had allocated for the rebuttals, I shall use the first 3 minutes, and then my co-counsel shall use the 2 minutes. In first addressing the precautionary principle that the first respondent has addressed, that the biosafety law came after the implementation of this agricultural issue, the implementation of the genetically modified organisms. However, we also submit before the Honorable Court that the Cartagena principle as well as the Rio Declaration binds them. And in this instance, it clearly states that the burden, once the petitioners or the people who allude that the rights have been violated, it is now the responsibility. They cannot throw back the responsibility without showing how this effect, or rather without proving what measures they have taken. And as well, the second counsel has cited the case of Raila versus IBC, and rightly the doctrine that he has cited. However, we also implore this Honorable Court to consider the doctrine of the lex specialis as well as the leges posterior espiores subroganti, in the fact that this court is only concerned of the environmental issues that is before this Honorable Court. The procedures that have been set in the biosafety laws ought to be considered. And in that regard, we humbly pray that this court disregard the cases that they have stated. The first petitioner, the first respondent as well, cited the case of Law Society of Kenya versus the Attorney General. It is our humble submission that they have employed a false equivalence to the parimateria fact that we have. In that case, the court did not address the issue of the safeness of the genetically modified organism. It only addressed on procedure. And what did the court say? It addressed that the Attorney General, or rather the government, had undergone all the procedure. That is, the contained use as well as the environmental impact assessment. In this instance, they have no iota of evidence concerning the environmental impact assessment that was conducted before genetically modified organisms were introduced. Now, thank you, my lord. in the issue of Law Society of Kenya versus the Attorney General, the court was categorically observing the procedure. And it went ahead and said that given that these procedures were adhered to, the petitioners did not prove any point that the procedures were faulted. But in this instance, we are proving that it is a false equivalence to the case that we have. They have faulted the procedure once they did not conduct environmental impact assessment, as well as the contained use that was indeed conducted was not in the effect of knowing the risk assessment. And moving on to the issue that there is an alternative. Indeed, we also rely on the same, that the Biosafety Act, on the procedures that it provides, the procedures that it provides includes the environmental impact assessment. Our point is this: they did not conduct environmental impact assessment in this instance. On the issue...
Okay, Council, do you want to cede the floor?
Maybe I can just use 1 minute of her time.
Less than a minute.
On the issue of an alternative remedy that the second respondent has cited, we do concur that Article 119 of the Constitution provides for an alternative. However, we implore before this Honorable Court, relying on the case of Jawara versus Gambia, on the available the remedies that this court has, which we seek, that the reason why we are coming to this court on the structural interdict is because this court has the power to ensure that it ensures that the remedy that we are seeking, this court shall ensure it supervises compliance. And in that regard, it is our humble submission, as well as relying on paragraph 25, that they seek, we have a duty to inform them. Pursuant to paragraph 25, we sought for this information. But what did they do? They failed to provide this information. As this court retires to make a judgment, we humbly pray that this court shall reiterate the words of Justice Madan, where he stated that when you leave this place, raise your eyes up to the hill, utter a word of thankfulness for your rights have been protected. The citizens of Idaya are looking up to this honorable court. They are seeking justice. They are seeking that this court shall indeed give justice, and we pray and we humbly submit.
Thank you, Council.
Much obliged. My Lord, the submissions of the respondents make one thing clear, that we are dealing with a government that will take high risks will take risks with the lives of people, even when there are alternative measures that would not have put people at risk. And then they will come before the court and say, I mean, at least we did anything. We think the government should be held to a higher standard. It is not proportional, it is not fair to the people who have lost their lives, and we think it is extremely problematic. We think the government ought to give compensation because there is money that was allocated 5 years ago, and there was a plan that was put within those 5 years. My Lord, the projects that the governments have put in place, none of those projects were outside of that 5-year plan. The government ought to have put in place a plan for disaster management, which they failed to do. Even if that does not persuade you, my Lord, we think that these funds cannot possibly be done with the projects that they have done, unless they are claiming that there is misappropriation of funds, which raises a different issue. With that, we are obliged. Thank you.
Thank you so much, councils. Yeah, thank you for the very passionate submissions from both the petitioner's side and the respondent's side. So I think my fellow judge and I will retire to consider the submissions and then deliver our judgment.
Yes, the little things really matter to them. So we'll start by welcoming His Lordship, Elias Ouma. Next, we'll welcome His Lordship, Tali. Will be followed by His Lordship, Kimani Kimani. Next, His Lordship, Professor Nicholas Orago. And finally, His Lordship, Dr. Omondi Owino. Thank you very much. I can assure you that they really loved it. You can see from the judges' faces, they are really happy. Yes, I'm just trying to create space for the awardees, so sorry if I'm not the center, moving just to the periphery, so that we can have an easy flow. So those seated near the trophies, kindly move to this side so that it can be easy to access them. And also let's create walkways for those who will be coming at the back. We really want to make it as efficient as possible. So we'll be starting by reading out the awardees for the research category. And for the research category, we shall also request our esteemed Dean, who's hosting us, Dr. Lando, to help me in awarding the research category. So I'll just start out by reading the best research papers in each category. The best research papers in each category. So in category 1, we addressing climate change and environmental justice in developing nation, state responsibility. We have Joyce Awino from Strathmore University. Hongera Joyce. In category 2, exploring the ethical and legal perspectives of genetically modified foods in addressing climate change, we have Miriam Rosasi from Kabarak University. Also, this position was tied by Patience Katambi from University of Nairobi. And for Patience, we'll definitely deliver the trophy. Sorry, it was mislabeled as a memorial, but we'll definitely give you the trophy. Please show her appreciation. Then the final category, international negotiations and agreement, analyzing outcomes, effectiveness, and implications for global climate governance and cooperation from Kenyatta University, we have Paul Mutuli. Hongera sana. That's the first gentleman we've seen. Yes, we'll now move to the best female researcher from Egerton University, Pauline Duta. Then we'll now move to the best male researcher from Kabarak University, George Njogu. And I must add, I had a conversation with some of the judges and they were really impressed by you, George Njogu. They asked me to pass their accolades to you. Pokea. I'll now move to the best researcher, second runners-up, from University of Nairobi, School of Law, Parklands, Angela Mburu. Next, we have the best researcher, first runners-up, from University of Nairobi, Patience Jue. And finally, ladies and gentlemen, the best overall researcher from the host institution, Riara University. A round of applause for Bobby Beeman. Yes, and that marks the end of the award for the research category. We shall now move to the Moot category. And I'll call upon Yes, so for this next round of awardees, I'll call upon Dr. Omondi Owino to help us in terms of giving and recognizing. So the best female oralist from Team 21, Joy Mwoke. Thank you. Still, the next category is the best male oralist. From Team 20, Ayaga Max. Your eloquence has been recognized. Yes, let me call on Dr. Professor Nicholas to help me award the winners of the memorial category. So we'll start with the best memorial applicant, Team 30, Moi University. Team 30, Moi University, you are recognized to have had the best memorial for the applicants. That's Vincent Kipruto and Ivy Musundi. A round of applause for them, please. Next, we'll have the best memorial respondent. We have Team 28, Kabarak University. And the last category, you notice that we got the best memorial applicant and also best memorial respondent. But this last one is for the cumulative marks of applicant and respondent. And that gives us the best overall memorials, which is Team 31, Moi University. Thank you very much. You can all take your seats. Final category, we have the overall best MC, which goes to none other than myself. So, colleagues, we shall now focus our attention to our panel of judges, because they reserve to make comments before we move and announce the best 3 teams which have represented us in this particular moot court competition. So I'll yield the floor and hand over the mic to the presiding judge. Thank you very much.
Thank you so much, Del, and congratulations to everyone. Now I will allow my fellow judges, perhaps starting from the farthest left, to give a few comments.
Thank you, Daktari. Good afternoon, everyone. My apologies, I didn't introduce myself. My name is Elias Souma. I'm the chairperson, CMR Africa. First, I would want to congratulate all of you to make it here. The purpose of moot court competition, if I can borrow from one scholar and marathoner, Eliud Kipchoge, it's about participation. And all of you have participated. So a round of applause for all of you. Secondly, as placed before you by Prof, in the spirit of competition, we must accept that there must be winners and we never have losers. We are those who learn for purposes of the next competition, especially in a moot court competition. The spirit is to identify the strengths in this competition, the challenges you had here, and go and correct them in the next competition. Most importantly, to learn the entire gamut of the theory in the tested hypothetical case. Thirdly, I would want to congratulate all those who've managed to get a trophy or who've been recognized as the best amongst the peers, your peers, I mean. It's only the beginning of many awards coming, so don't go back and keep the trophies home. Tali and Kimani used to grab all these trophies. I also managed to get some when we were young. It's just a clarion call so that you can also go back and have a reason to get those trophies. Fourth, to those who managed to finals, this time around I was not privileged to judge the preliminaries, but from what we have in the finals, just the usual comments if you've participated in previous competitions is first, have a good grasp of the hypothetical case. The facts. You should never be wrong on the facts. You can be excused for not knowing a certain aspect of law, because all of us here, we are still reading, we are still learning these new areas of law. But you should never be wrong on the factual aspect. I can tell you, all of us who are practicing, once we have a case before us, the first thing we always want to know is every detail and factual aspects that are for and against our clients. And it is in that spirit that when you have a hypothetical case, take like a whole or 2 days or 3 days before you go to do your research, just understand what is it that you're dealing with, such that when you come here, you don't misquote the fact. Secondly is the research aspect. It's very important and critical that you know what you're coming to do. You know, because it's submissions, you're submitting what you know. Whatever you're putting forth is not coming from us, it's coming from you. In Gen Z word, when do you want to show? So have that spirit, especially when you're at the podium, that when do you want to show judges, you get it. And then lastly is to wish you well. We endeavor to have this competition to go regional, so that next year we don't have it as a domestic competition, but it be a regional issue. Regional competition that you can also meet your counterparts. The cross-border practice is something that is in the offing, and it's high time you do serious networking with your colleagues from the regional arena. Otherwise, I thank you and may God bless you.
I will introduce myself again. My name is Tali Israel Tali, and just a few things from me. I'd want to start by thanking the bailiffs. They mostly go unnoticed, but they do very great work. You did good job. But most importantly, to encourage you, next time don't be a bailiff, participate. I hope you learned. Earlier said it's participation. So I hope you've learned a lot. If you are starting over, understanding what people do in Moot, take it up. You never know. Maybe you're sitting on your talent. Number 2 is to the research category. I want to encourage each of you, from the feedback I saw when the researcher presented, there is a lot of interest that people have built and developed in the research, and that is a very good and commendable thing. My advice is, when you go back to your schools, develop those papers, send them to the platform magazine, go and check out the platform magazine, send them out, they'll be published, check out climate justice journals, talk to Daktari here and Prof to review and assist you review your papers, and you never know. You might find yourself being published in the Harvard Law Review. Also, Daktari talked about you attending COP. Go and think about it. Even if it is not COP, there are many climate summits outside there. And that is to all the researchers. Submit your paper. Say, this is the topic, I've researched this, we can talk about this, and then you never know. It will give you good feedback. For the Mooters, everybody who participated in the Moot category, it's quite commendable job. I was privileged to judge from the preliminaries. All of you did well. All of you showed effort. And I want to encourage each of you, keep the interest burning. Hope you've interacted. I don't see many sad faces, although I can see few. Keep interacting with each other. I hope you've gotten a contact or two, so that after here, it doesn't end here. You continue building on the relationship that you've started here. Otherwise, I wish you all the best, and let's see you next time, even in very larger platforms. Thank you.
Thank you very much. My name is Derek Kimani, and I was one of the judges today. And I enjoyed listening to each and every one of you. For those of you that appeared before me in the preliminary sessions, I insisted that this is an exercise of not only learning, but also having fun as well. So I hope you did have fun as much as I did. If you didn't, that's on you, man. Yeah. Brevity. Do not overemphasize. We get you. We get you. And most of the time, we just want to make, you have had a lot of time to prepare, and there's the temptation to want to make every submission on earth in relation to the particular point that you're making. You do not have the time. So be brief, be succinct in your presentation. We hear you, And when you're directed by a question to move to the next point, move to it. No learning is ever in vain. That has been emphasized from Elias, that it's about participation, and you might have lost and do not register that. You don't want to process that it's just about participation. But to just further emphasize the position, no learning is ever in vain. No learning is ever in vain. You have learned a lot, might make you interesting at the dinner table, might make you interesting in the next class, but it is definitely worth it. It is definitely worth it. This endeavor was not a waste of your time, regardless of whether you won or did not win. It was worth it. And finally, make friends. I hope, and I'm certain that the natural justice team has created an environment for you to interact with your colleagues, be it at the hotel or be it here at the university. Make friends and do not take these relationships that you build in such engagements for granted, because they will come in handy, not only for your further engagements in this space of Moot Court, but also even in your professional. So make friends and cherish this moment. They're all you have for now. Thank you.
Okay, thank you, Kimani or Kimani Squared. I think it's been a complete privilege to be here. Thank you for everyone that has made this possible. Thanks Dale and Natural Justice for providing this opportunity for our students to learn out of class. I think experiential learning is critical if we are going to be able to be the baked lawyers that everybody wants us to be. So this is an opportunity that is quite critical to each and every one of you. And we also appreciate Dale for ensuring that everybody from all the parts of the country are here, and not just the Nairobi teams. You know, there are some people who only think about the Nairobi teams. And for us in Mashinani, sometimes nobody thinks about us, but I'm not complaining. Lando, I'm not complaining. Riara University is home. I used to teach here about 2014. So don't look at my face, I'm old. So for the people that we had a privilege to listen to, why do we ask questions? Sometimes it's just to guide you. We're looking for a certain aspect of your argument that is not coming out, so we just want to guide you and get clarity. So it's important for you to respond to those questions so that we are guided as to how to relate with the presentation that you're making. Or sometimes it's to actually throw you off. For us to see, are you prepared enough to go back to your logical arguments after we have thrown you off your own argument? Or do you lose it completely and you lose confidence? Because if you lose confidence, the other team is looking at you, is it? So you shouldn't lose confidence. Sometimes we ask you to clarify, sometimes we ask you to guide, sometimes we just want to see if you're able to go back to the logical argument that you're saying. My colleague has talked about preparation. Preparation is everything. You build your confidence on the basis of your own preparation. If you have researched well, you know the authorities that you want to use, you know your law, then it's easier to be able to convince people of what you're actually saying. Communication is not oral only. We also look at your the things that you're not saying, the things you're saying with your body, with your face, and we see if you think we're irritating you by our questions. You shouldn't show emotion when you come. And even if you feel that your team is not doing very well, just talk normally and be confident that you have done your best in the presentation that you're making. The authorities that you were using, get to read and understand the authority and how it supports your case. And don't, even if there are authorities that do not support your case, please tell us about them. And if you can be able to distinguish them, either on the basis of the facts, or you're able to distinguish them in any other way, please, it's important that we know. Don't hide authorities and look for, to cherry pick other authorities that might support your argument without telling us and trying to distinguish the other authorities that are relevant to the court. So that it's important, therefore, that you use your authorities effectively. And then this is to a specific person, and so please don't feel attacked. But Kelvin wanted to kill us with Latin in his rebuttal. It's death by Latin. So several Latin words coming one after the other, and we are, and without being able to explain that. So we don't know what, Kelvin, what did you want to do? You wanted to kill us with Latin. But it's all in good humor. We are privileged to have listened to you, and we hope you keep working to be able to better your oral skills.
Yeah, thank you so much, Prof. As you've heard, Omondi Owino is my name. And let me, just allow me to do something unprecedented. Let me just acknowledge my students in the audience. Do I have any students? You can just wave. Yeah, I think that's encouraging. A teacher without students is an imposter. And so just to dispel that myth, I get very excited to see a large number of people sacrifice their Saturday to come and engage in an intellectual duel. It is something very exciting. And what excites me about it is, when I started teaching many years ago, I didn't realize the impact of that calling. And along the way, I met a colleague who told me that when you're teaching, you look at the outcome, you do not look at the income. Because if you look at the income, you will not continue teaching. And now this is the outcome. I traveled to Kericho to do a matter, and to myself, I'm just any other lawyer in the courtroom. And when the court adjourns, I have 5, 6 people crawling out of the woodwork and saying, yes, you taught us at the Kenya School of Law. I think that is better than any income you can wish for. And the other thing also that I have learned is that as opposed to just standing in front of a class and teaching, you are nurturing the next generation of lawyers. And this is where it gets exciting. You do not know where they will end up. You do not know which one will become a CJ, which one will become AG, but unfairly you will be able to take credit. So it's a very exciting thing. And I want to encourage those who might feel down because you did not end up where you had anticipated. Personally, I become stronger with failure than I am with success. So if I get a negative judgment from the court, I always find that I try to look at it and read everything that the judges wrote. But when I am successful, I go for lunch with my partners. So that can tell you that I learn more from failure than I learn from success. So failure is not failure. It's only failure if you interpret it as such. It's an opportunity to ask why Ayaga went with everything while you were seated there. Perhaps he's been watching Toastmasters, doing what? So what could you do to go past him? That's an opportunity. And so keep on striving. It's a good cause. I hear people say, trust the process. I am here because I trusted the process. I was an ardent mooter. And so if I'm here, you will also go past me. I think that's what I can say. And having said that, Del, do we come back to you? Or do we proceed and...
Yes, so thank you very much, and I hope you've taken note of what the judges have said. And I can also confirm that Dr. Omondi Owino taught me at the Kenya School of Law. and Professor Nicholas Orago taught me at University of Nairobi. I am a product of the two great gentlemen. Yes, just before you make the announcement, I'll also request one of the students to at least volunteer to give the vote of thanks. It shall not come from Natural Justice or CMR, but shall come from the student. So any student to volunteer for a vote of thanks? Hakuna mtu ameguzwa? Yes, I'll go with you. You raised your hand first. Yes, after this. So just sit down, and after the final session, you'll come in and give a vote of thanks. So I'll now just hand it over to the judges to give us the final verdict and also award the best 3 teams.
So it is my pleasure and singular honor to invite Justice Kimani Wakimani, who will render the decision of the bench. Justice Kimani.
Thank you very much. Ladies and gentlemen, we thank the parties for their erudite submissions in this matter. After careful consideration of the arguments presented, it is the finding of this court that the petition brought forth lacks sufficient merit to warrant the relief sought. It is evident that the claims do not meet the necessary legal standards required for the court to intervene. Furthermore, while we acknowledge the importance of the issues raised, we are of the view that the petitioners did not establish a clear breach of rights necessitating judicial action at this time. In light of these findings, we dismiss the petition in its entirety, but this court appreciates the efforts of all counsel involved and recognizes the significance of public interest litigation, and thereby each party shall bear its own costs. Thank you very much. Should I read again? The petition is dismissed, so we have the respondents prevailing. Thank you.
Yeah, so the petition is dismissed, each party to bear the costs, and I think we give it back to Dell to tell us which other categories do we have for award.
Thank you very much, and congratulations to the respondent. What that means is I'd like to just invite all the judges in front just to award these categories. Have a photo with the final 3 teams. So I'll start by reading out best team, second runners up in this particular competition. And we have Team 23, Strathmore University. Judges, please. These are the best 3 teams. A round of applause for them. Santeni San. I had a conversation with the lecturer and he told me that it's your first time mooting. So congratulations. The respondents having carried the day goes without saying that the first runners-up is Team 30 Moi University. Asanteni sana. Good job, good job, good job. Ladies and gentlemen, the team that has carried the day, I want us to welcome them in a special way. A standing ovation, because they deserve it. As you can see, battling against 32 team is no mean feat. Please help me welcome Team 20, University of Nairobi. A standing ovation. Yeah, we can take our seats so that those taking photos can capture this beautiful moment. Very two distinguished gentlemen. Can also photobomb. All captured? Hongera sana. I know the judges are also asking for an award for the best judge. We will discuss. I think the participants will also caucus and discuss and come up with the best judge. Colleagues, yes, apologies. There is one single award I might have omitted. There is one single award. Mistakes happen. Let me just confirm. Yes, I'm told there is also I'm told there is what we call a judges award. So the judges agree on who to award as an extra, not for the judges, for the students. It's your discretion to award someone based on what you might have heard from the participants. What I'm saying, there is a special award by the judges for which natural justice does not categorize. So it's up to you to award someone based on what you observed. For the two teams that were here. Yeah, they're having one.
The judges have deliberated and they've decided to award the judges award on the basis of passion and commitment to the case. And on the basis of these considerations, the judges have decided to award the Judges Award to Ivy Musundi.
We'd also like to give some awards to the judges, but I'll use my discretion in terms of giving this out. So we'll be awarding Professor Nicholas, Dr. Omondi, and Elias. They'll be getting an award today. I'll explain why Tali and Kimani won't be getting one. It came to our attention that something happened. You are too harsh. Yes, please, the judges, you can receive your awards, please, collectively, to save on time. Thank you very much. We can confirm those are not brown envelopes. Yes, so colleagues, friends, we've come to the end of the third environmental and climate justice moot, and we cannot overemphasize what the aim could have been. Okay. Yes, because for us, we really want to award everybody. There is a last category that we've been told to award, And this category goes to Team 32, Maseno University, for being a late entrant into the competition. They only had about 4 or 5 days to plan, but then they didn't really back off, and they still made it for the competition, and it's also their first time. And as a young university, it's usually our duty to recognize the people who come to face the giants, which is who you are. So, representative from Maseno University, or the entire team, just please come and and after this, we'll have a collective group photo for all those who've won something. So if you've won, just please be in the aisle, then we'll proceed.
Thank you very much. Can we please have all the teams that have won something to come to the front? All teams that have gotten an award, please come to the front for just one team or group photo. Kila mtu mwenye amepewa zawadi, tafadhali, jongea mbele. Bobby, you can come and team. Anyone that has an award, please come. We just want to take a group photo. Tuharakishe kidogo, masaa imeenda. Just come, just come. If you have an award, judges, kindly, let's take a group photo with them. Everyone sits for... Please bring your trophies and your certificates, everything. Can I borrow your seats? Ndio wenye wako mbele wakae chini. Yes. I'd kindly like to have these seats in here now. Wengine wasimamie juu pale.
Yes, as we have our seat, the vote of thanks, then announcements, then we leave. We'll talk after this. Okay.
Please recognize our directors, Alex, and especially Karen, our programs coordinator.
Okay, so thank you. Yes, as we prepare for the vote of thanks, may I have your attention, please? May I have your attention so that we can leave before the rains? Yes, as we prepare for the vote of thanks, also let me recognize some of the people who made this possible. Allow me to recognize so that they can just stand up and wave. Some of the directors of CMR. CMR is Center for Moots and Research. So allow me to recognize Mr. Alex Mbaya. Also allow me to recognize Karen Koech. Yes. Is there anyone from CMR in the gallery? No, Elias already introduced himself, and he received the necessary recognition. But that's Elias Souma and also Tali Israel. So the vote of thanks, just 2 minutes for vote of thanks.
Thank you. All protocols observed. Good afternoon. My name is Bichanga Jefferson, a student here. I'd like to start by thanking my fellow colleagues for having made this a success. I know all of us have done their due diligence. We've worked overtime. We've applied ourselves, and indeed, as we have seen, there is quality in this gallery. Kwa hivyo tujipe makofi ya nyayo. Mnajua makofi ya nyayo? Nasema moja, and then tunaclap mara tatu, like moja, 1, 2, 3, 3 times, sawa sawa. Moja, pili, tatu. Unfortunately, our government is borrowing more than just makofi from Nyayo. Those are my personal views, not of CMR or... Anyway, moving on, asante sana, honorable judges. Indeed, they have done their due diligence also. They have guided us. They have asked us questions. They have tickled our minds. And I think coming out of here, we have many more questions that we'll be engaging in, isn't it? Kwa hivyo, tuwape makofi. Moja, pili, tatu. And also our coaches. We've been seeing coaches around, tumauliza maswali, and we have been edified by them. Just to thank also Natural Justice for having convened this Moot, for making it a success. As students, of course, we have had opportunity to engage with each other, and this would not have been a success apart from the efforts by Natural Justice. Kwa hivyo, tuwape moja, pili, tatu. I can see some people from the older generation are afraid na mambo ya Nyayo. Sijui kama walikuwa tortured during those days. Acha tuachie maneno hapo. CMR Africa, thank you for also partnering to make this a success. They have been valuable even in offering training, offering guidance, and coaching us on different aspects regarding this Moot, and therefore receive our recognition even as students. Let's give them a round of applause. And lastly, Riara University, indeed, this is a distinguished campus, as you have seen, and thank you for hosting this Moot, for having made it a success. This is one of the best campuses in the country, and let us give them a round of applause also. And lastly, I would wish to thank the Almighty God for giving us life, energy, vigor to make this a success. Indio, we started with thanking God, and lastly, we are finishing by recognizing God. So let us give God thanks when you go to pray at night, isn't it? Ata pia makofi. Thank you very much, and enjoy yourselves.
Okay, just one short announcement. The bailiffs and the team from Riara University, please let's meet out here after this. Sawa sawa.
The host having spoken, nothing more to add from my end, but just a few announcements. For the students who are yet to receive their reimbursement, please liaise with Alex or Grace from Natural Justice. I think today it's for every student, whether you're out of town or Nairobi student, we will try and reimburse you a transport for the 3 days. Lunch? Yes, I think lunch is ready and served. For the people who are being accommodated at the hotel, I know you had checked out. For those who might not, in this exceptional circumstance, get back to Eldoret, Mombasa, or Kisumu. That being said, if in case you have a question, kindly see any of us, should be Alex, myself, or any colleague from Natural Justice. And with that, the ceremony is officially closed. Thank you very much.